in the definition of gender-based violence, there's mention of men, women, boys and girls. And don't we need to include gender there or transgender? Because in the definition of the other words, for instance, the gender equality, gender equity, and in the definition of gender sensitive, there is, okay, for gender sensitive, there's mention of only men and women. And then for the others, it then includes gender. So I'm wondering if we are not missing something in this definition of gender-based violence, because in the application, it's clause, it says that the murder law applies to issues that include sexual orientation. And also it says the application of the model law takes into consideration the full definition of GBV. So my question is that a full definition if considering what I've alluded to? Thank you.
Before the committee comes in, when we had our last consultative meetings with parliamentarians, the lady from the Commonwealth actually pointed this fact out, and she's the one who sent us all those definitions, which I beamed up during the first part of our session. And I promised her that we are going to change the definition of gender-based violence to try and incorporate all the bits and pieces from all three definitions, or let me say 4 definitions, including that of SADC. So that's why you've seen I've quickly highlighted it in yellow so that I don't forget. So thank you very much for reminding us. And we are definitely going to change that to reflect or to mirror the 4 definitions so that it's complete in itself and everyone is satisfied. Is that okay? The rest, the committee, is that okay? Okay, thank you very much. Anything else? Yes.
Yes. In the definition of gender sensitive.
Gender equality?
No, gender sensitive.
Gender sensitive. Oh, you've gone down. Okay, she's on page 59. Please turn to your page 59. Gender sensitivity, gender sensitive.
Yes, I think it's related to what I've just said, because it now only refers to gender needs of both men and women. What about the other, the boys and the girls and the other gender?
Okay, class. I'm so used to teaching. I said class, participants. Sorry. Participants. Members of the committee. You heard Iswatini's comments. How do you suggest, Iswatini, when you make a comment, try as much as possible to suggest a redraft so that I don't start redrafting for you. You are the drafters. So can you suggest a redraft to make it more gender sensitive?
Thank you. maybe I wouldn't have a suggestion because I'm not too well versed in the gender issues. But for this latter intervention, I was hoping that even the others are included. Like we said, then maybe it should read gender sensitive means acknowledging and taking into account the specific gender needs of men, women, is it boys, or which one do we start with, girls or boys, and then maybe go on to consider the comment that I made earlier about the other gender. So I don't know how we're going to put that.
Lesotho?
No, thank you very much. I don't know, but I don't know if it's wise to keep using boys and girls, men and women, unless if there's a problem with it. But I would suggest that maybe we adopted the use of male and female. Wouldn't that be all-encompassing? Instead of saying men and women, boys and girls, like, because for me, it's just a matter of stages at which they are at, whether they are still like young adults or grown-ups, but they are both female and male. So I don't know if maybe that would not help.
Okay, Namibia?
But I think there are also categories such as people who identify as non-gender, binary, and all this. I think for purposes of consistency, we should just, in all the definitions, keep within that framework, men, women, because I see in some instances there's reference to men and women, in others it's men, women, like the next one includes girls and boys. And then in other parts, we talk about non-gender, binary person. So maybe just for purposes of consistency within the definitions, should rather be needs of men, comma, women, comma, girls, comma, boys, non-gender, binary people, as a suggestion.
Any other suggestions? Okay, sometimes we targeting boys and adolescent girls. Sometimes we are targeting the elders, men and women, and so forth. But in this particular one, let's try to redraft it to something like this. Means acknowledging and taking into account specific gender needs at all levels of planning, implementation, monitoring, and evaluation. What do you think?
I would agree with that, rather to take it out
Okay.
completely.
Okay. Have we got it, our rapporteur? Huh? Yeah, I just read it and said, take into account the specific gender needs at all levels of planning, implementation, monitoring. I've just taken out of both men and women. Yeah. Okay, let's move on.
Would the same then apply to the next definition of gender stereotypes, which also refers to
Which one?
the next definition, gender stereotypes?
Or gender stereotypes? Yeah, we'll do that.
Okay.
So it means the beliefs held about traits and activity domains that are deemed appropriate for each gender based on, so you just say instead of women, we'll just say for each gender based on their conventional roles, blah, blah, blah. So we settled now on that. So when we are proofreading the document, we'll try as much as possible where we are not providing for a specific need, just to be general and say gender, each gender and things like that. Okay? So let's proceed. Any further comments on page 59? Yes, Mr. Charles.
Yes, thank you, Chair. With the definition of harmful practice,
Which one again?
Harmful practices.
Okay, harmful practices.
Yes,
Yeah.
just a query. So will harmful practices amount to GBV? And if that is a yes,
It is GBV, yeah.
so will it be included in the definition of GBV, gender-based violence, to include harmful practices?
Yeah, I think we have included it. If we're not, we will.
Mm.
But we need to still explain it.
Mm.
You know, as drafters, even if something is within another definition, if it requires explanation and definition for further understanding of the user, then you take it out and you define it.
Yes.
Yeah.
But the word itself doesn't appear in.
You can, if it's not already in GBV, we'll put it in.
Thank you.
Okay.
Okay.
Anything else?
Est-ce que je pourrais prendre la parole, s'il vous plaît?
Page 60. Oh, Mozambique? Oh, Madagascar.
Madagascar. Oui.
Okay.
Bonjour à toutes et à tous. En fait, par rapport à la définition, j'aurais une suggestion si on pouvait intégrer le terme survivant et survivante, parce que en lisant plusieurs documents concernant les violences sur le genre, j'avais vu que le terme survivant est souvent employé par rapport aux textes internationaux. Donc là, j'aimerais suggérer qu'on puisse intégrer ce terme-là au niveau des définitions. Merci.
Can we have your definition, please?
D'accord. Alors, selon ma compréhension, les survivants et survivantes sont les victimes de violences basées sur le genre qui ont survécu aux violences qu'on leur a infligées, en fait. Dans ma compréhension, c'est ça. Donc, je ne sais pas ce que vous en pensez, si on pourrait l'intégrer.
Attempt to now draft it as a definition, not as a statement. We'll give you a chance to define it and you'll come back to us. Okay? Any other comments on the definitions? Yes.
D'accord,
So
merci beaucoup.
your mic? Yeah.
I just want us to look at the definition of the word perpetrate.
What?
Perpetrator. Perpetrator.
Oh, let me take this. What word was that?
Perpetrator.
Perpetrator. Okay, good.
Yes. And I'm not sure if what is written, because it says it means a person who has subjected another person to gender-based violence, or is a person who has been convicted of a gender-based violence offense. I know the people of human rights activists, usually they are very sensitive as to how we name the suspects, so to say. So I don't know whether a person who has, or maybe who is allegedly has committed a GBV offense, at what stage do we call them a perpetrator? And at what stage do we call them something, maybe a suspect or something else? So, but from the definition, I'm not sure whether that addresses my concern, that it looks like by just being a suspect of GBV, you're already called a perpetrator. Yeah. Because that's how it's been used even in the text. So is it okay the way it is, or maybe we should consider? Because it says once the person has been convicted. So what about before the person is convicted? So I'm a bit lost there.
Yeah.
Thank you.
They use the same word, and it's not a problem in how it's actually used for purposes of the model law, because the same provisions would apply. And if they have actually been convicted, there's extra provisions that will apply. So when you read the model law, it doesn't cause any confusion whatsoever. And I've tested it against the provisions. So I just went along with the words there, the protagonists actually use when dealing with perpetrators of gender-based violence. So obviously you become a convicted person, a person who is convicted of. So when we come to there, you can test it to see whether we're actually not confusing ourselves. When we come to the actual substantive provisions. If you want, we can mark it, we can star it that, because I think your problem is this part.
No. My problem is not actually whether it's been used well or not. I was actually worried about the human rights activists, because sometimes we are told not to use certain words because it's like they are condemning on the people. Because, you know, sometimes you are told the presumption of innocence should always be there. So sometimes you can call somebody a perpetrator, and some activists could actually take that to be offensive on the person. So it's not about whether when it's used, it creates a confusion or not. I'm just worried about how it feels to the eye. That's all my worry. Thank you.
I don't know. For purposes of this model, I don't think it should be an issue, even to the human rights sector. I really don't think so. Perpetrator, it's used in the ordinary sense of the word perpetrator, but we are targeting it against gender-based violence. That's what we are doing. It's the ordinary use of the word. And I don't see it coming out offensive, even to human rights, because we are promoting human rights in that sense. They're actually violating human rights. So I don't know, we can't win with that one, but I would suggest let's leave it in, because that's what the protagonists use when they are dealing with GBV.
No, it's fine.
So we can start it, highlight it, and come back to it at the end and see whether maybe you can find another more suitable word that we can use, and then we can replace it after discussion. So I'll start it for now.
It's because, like, usually in our criminal law, we would have a person as a suspect, and then it will be an accused person once the charges have been read to him, and then it will be a convict once he has been convicted. Some people are very sensitive as to at what stage do you call one person what.
That's
but
what I'm
fine.
saying.
So
that I'll start it, and when you find a more suitable word, when you find it, then we'll see how we can best replace it towards the end. We'll give the benefit as of now, as we are proceeding with the model law, to the use of the term perpetrator for purposes of the protagonists. But if we find that it's not suitable the way we use it, and then you, by that time, you will have found us more suitable words.
Okay, let me say, from what it is defined, once somebody has been convicted and you call them a perpetrator, I'm fine with it. But by just being a suspect, that's where then I think the word might be too harsh. Like before you are even taken to court, like when there's just allegations that probably it's this person or that person who did this, I think that's where then I feel like to use the perpetrator across, then that's when maybe we might need to.
You see, I'm not like disputing you.
Yes.
I'm saying find a more suitable word.
Okay.
So at the end of the discussions, instead of prolonging the discussion whether the human rights against the protagonists of GBV are correct or not correct, whether the word is suitable or not, we'll find a better word. You'll find a better word which we can use.
Thank you.
Seychelles and then Namibia.
Okay, quickly, just to add on to Lesotho. Maybe we can look at the word offender, if that's a better word for it, okay?
Namibia.
No, my comment was on the previous comment by the lady from, was it Mauritius? No, Madagascar, sorry. Madagascar. The definition of survivor is construed as part of the definition of victim. So if you go to the definition of victim, scroll down all the way to the end of the definitions. Victim,
That's on page 63.
63, yes. So if you see at the end, so including a survivor, and the word survivor shall be construed accordingly. So I don't see the purpose of defining survivor as separate when it's construed as part of victim.
Madagascar?
Oui, oui, je suis tout à fait d'accord avec la collègue de la Namibie, mais je propose quand même qu'on inscrive ce terme-là à côté du mot victime pour ne pas justement être nouveau quand on verra ce terme-là ou quand ce terme-là sera utilisé dans nos langages. Mais effectivement, je suis d'accord avec vous, c'est un terme interchangeable en fait avec le mot victime. Mais ce serait bien, je trouve, qu'on puisse l'ajouter du coup.
Okay, thank you. Let's proceed.
You can just delete you had inserted survivor somewhere, just flag it so you know to delete it.
I think she's still insisting
okay.
that we say refer to definition of victim, but it's not necessary.
Yeah.
But let's give her the benefit of doubt and let her come up with a definition, and then we'll look at it. Yeah. Okay. Any further? Yes, Namibia.
The subsequent provision, which is sub 2 after the definition of victim, there's a 2 and then there's a 1, and I'm trying to, maybe you can explain what for the purposes of the definition of competent authority, the following shall be considered with respect to gender equality, equity, or gender-based violence in relation to specific contexts and perpetrated by specific persons, the family, the community, conflict situations, and violence condoned by the state. And then there's a 1 that reads violence committed by, should it be E, or is that a separate?
You were asking for the abundance of caution clauses?
Yeah.
Where you are discussing which one? The competent authority,
and then
there's gender-based violence.
No, competent
and then
authority.
There's the one on victim.
Go back up. So the one on competent authority.
Yeah.
The specific persons are listed as family, community, conflict situation, and then there's a 1, violence committed by. Should it be E, or is that a?
Oh no, it's just a mistake. It's supposed to be E.
Okay.
There's an and there. It's just a typo. Sorry.
Okay.
Yeah, it's supposed to be like that.
Okay.
Yeah. Thanks for that. Any further comments on that? Yes, Shels?
Yes, following on Namibia's comment. So
Which
those
comment?
following on from her comment.
Oh, the one where there was a mistake?
Yeah. So is subsection, but paragraph 2 and 3, is it tied in with the definition of victim as following on from that? Because it seems it's disjointed. I don't know if those 2 paragraphs follows on from victim, or is there a new definition which is supposed to be starting?
That's 2.
Yes,
Yeah, that's 2. That's subclause 2.
from the definition of victim.
No, subclause is, remember, if you go, you have to go right back as a drafter, check your numbering, go right back up. We are talking about interpretation, right?
Yes.
So under interpretation,
Okay.
we've got 1 there.
Oh, it's the
Subclause
last-
1.
It's the last definition.
Thank you.
Okay. I didn't- Okay. Okay. Thank you.
Yeah. Are we okay then? Yes,
Yeah,
Namibia.
I know we agreed not to discuss form and and structure, but it's an interesting way of drafting because at least in our experience, those abundance of caution clauses would form part of the main definition. So competent authority would then have a subparagraph. I mean, that's just our style, but I find this, like you said, it looks a bit disjointed when you have that subclause following and then there'd be no leading clause that leads and says these are, something along the lines of.
Okay,
yeah.
because the way it's drafted here, we also have that style, but there's various styles of doing definitions. When you don't want to have block definitions, you want clear-cut definitions, and then these are just abundance of caution. You just got an abundance of caution. You want to enumerate further, and you don't want to do it within the definition because you may distort the general meaning. So you can go into another subclause and put all your abundance of caution clauses. That's all it is. It's much clearer. So they go back and say, for purposes of competent authority, we've added this. For purposes, it's just a clarification clause, basically. But the definition itself is clear to its intent. But you are just making the user aware that if you don't understand what psychological emotional means, if you don't understand what intimate partnership means, then go to your abundance of caution clauses, which list them. That's all. And there's nothing wrong with that. Yeah.
It may help.
Follow-up question, just quickly. So if that is the case, then at the end of the definition of victim, should we then not put a full stop?
Where we victim.
The
definition of victim.
Yes, they wait just right there.
Yeah, there should be a full stop before subclause 2.
Down.
Yeah.
Yes, they.
Sorry, no, it's just a mistake. There should be a full stop. Yeah.
Okay.
It is a full stop because we are starting a new subclause. So it's obviously a full stop. Yeah.
That, or we put the sub 2 and 3.
No,
at the top.
let's not put them. Let's not mix up the international definitions. These are, as I say, it's an abundance of caution clause. Normally, we are not descriptive in legislative language. You are not descriptive because you want to leave it a bit vague to include other things. But for purposes of model laws, they ask you to put these extras, and it's good for yourselves. Because if you go back home and you want to define, because this is for purposes, remember always, for this law. So if you want to define, let's say, victim, and you want to include in the term victim the rest of these abundant clauses, then you can do so. If you don't want, you leave the pure definition, which I would do if I was drafting in my national law. I wouldn't put these abundance of caution clauses. I wouldn't put them because it may distort the meaning. But for purposes of a model law, it's essential that those who are going to adapt it understand the extent of the definition, what it may include. That's all, because these are not even exhaustive. So let us be cautious how you read your model law. Don't read your model law as if you are reading your own national law. You'll be making a great mistake. So even yourselves in future, when you are drafting model laws, you have to be cautious not to get confused that I'm drafting a national law, but you're not. Even if the language of the model law may be very different than the language of your own national laws, which is more strictly construed. So you have to be very careful when you are drafting your own model, your own national laws, as opposed to a model law, which is a bit loose to allow the person who is adapting or adopting to include or exclude. Okay, yeah.
So are you just confirming that 2 and 3 is following up from the definition of victim?
Pardon?
Are you confirming that subsection 2 and 3 follows from the definition of victim?
I'm not getting you. What are you saying? We've put a full stop, remember?
After accordingly.
Now, this is a new subclause. These are abundance of caution clauses. You've learned that in drafting.
Yes.
Yeah, so it just for the benefit of no doubt.
Yes, I understand.
Create no doubt in your mind.
What
Yeah.
I was just proposing, why not move 1 and 2 after 1, so that it removes all this confusion?
I'm
What
not
do you mean?
understanding what you are saying. You are
Maybe let me
confusing
try and,
me.
yeah.
Yeah.
So 1 is all the definitions. So that's one clause.
Mm.
Then the second clause is the abundance of caution for the definition of competent authority.
Yes.
The next one would be, so you can't, one is, it includes all those definitions
Yeah.
up until victim. That's where 1 ends.
Mm.
Then the next clause is the abundance of caution clauses. Does that make sense? I hope.
Yes,
Okay.
but still it is for all, no? So it still clarifies everything.
It only clarifies certain issues which are crucial
Yes.
to the user. There's only 3
Yes.
which are clarified. The others are not clarified. We haven't put, because they are straightforward.
Mm.
Yeah. And you must also remember that you are dealing with many groups when you are doing the model law.
Mm.
A model law is always compromised golden standards. You have got the human rights groups, you've got the advocates for GBV, you've got civil society, which advocates both. So you see, we've dealt with all of them, and they have made their own suggestions in here. So it's very difficult to include everybody. So sometimes you amplify as a compromise. You understand? Yeah. You see, even the definitions of GBV, I've given you about 4. So what we'll do, we'll just take bits of pieces here and there and try to put them into the definition of GBV. But it's not like a definition that you may want to use in your national legislation. You may want to expand or limit the definition according to what you believe you can actually deal with. Some people, they're just saying, we are going to exclude LGBT, but it's them. They'll do it in their legislation and not in this model law. This model law is very broad-based because it's a compromise. It's a model law which many people have put in their say. So we've come to a compromise on certain issues. Yes, Lesotho. I thought you were putting up your hand, and Namibia, yes.
Maybe for clarity purposes, we should say for the for the purposes of the definition of competent authority specified under subsection 1, something along those lines.
No, but you've already said the definition of. Why do you want to become obsolete? You are drafters, please. Otious, that's the word, otious. You want to put so many words when you don't need many words.
No, I was not putting it in there. I'm trying to explain it to him that for
Okay.
purposes of the definition contained under subsection 1, not.
Eswatini.
Mrs. Dara, with all due respect, we wouldn't be having this conversation if we had simply put this abundance of the caution under the specific definitions.
What we are saying, I don't want to cloud the broad definition of GBV, but we are trying to amplify it for better understanding. That's all. These are already included in the definition. If you read the definition, it uses broad words, psychological, emotional, all those. These are part of those definitions. So we are just clarifying it in the model. In your national law, you don't have to do this. But for purposes of all the other readers of the model law, it's better to have your abundance of caution clauses. In fact, you do have it as well. In fact, you put it maybe in a subclause as well. You do put it in a subclause. Yeah. You normally say for the avoidance of doubt. And if you really go to the gurus of drafting, they'll actually tell you that why are you putting this clause in for the avoidance of doubt? You have already defined, you have already stated in your major substantive clause dealing with that matter, what you want to legislate on. And then you go on to subclause 2 and you say, for the avoidance of doubt. This means that you've seen it in your legislation. The gurus will tell you that's nonsense, delete it. You're causing confusion. But for purposes of model law, it's easy going. You can actually amplify for purposes of your user. But in your national legislation, the gurus will tell you don't put for avoidance of doubt. Why? Who are you addressing that to? The judges? For the avoidance of doubt. You see, yeah, so meaning you are not sure of what your proposition is stating. Go back to your proposition and put your legislative sentence correct. Then you won't need for the avoidance of doubt. You see? So there's some things in drafting which have now come up, modern drafting. You don't use such word in national legislation. You're actually confusing everyone. Any other comments or? Let's go to part 2, the human rights-based approach and policy direction. Again, I hope you have read what is stated in italics there. Maybe I should read it just to remind us. It says, this part and the following parts have been drafted in a manner to assist member states to draft similar provisions with minimum amendments. The rights outlined in this part are a restatement. I'm sure we all understand what a restatement is. It's not exact wording of what is provided in the international convention. It's a mere restatement of certain rights specified in various international and regional human rights instruments on gender-based violence and member states' constitutions. The style of drafting is generalized as to the rights with specific reference or relativity to the issue of gender-based violence, whilst emphasizing the rights of women and girls. The draftsperson should use the content to develop specific provisions on the subject-related issues as conforms with the style and language of national law. The offenses and penalty clauses are inserted to remind SMS's drafters that they must provide for appropriate prohibitions, offenses, and penalties, which are put in strategic sections as indicators that punishment is required in relation to that subject area. So that's what we are looking at. Now, for your purposes, what I would advise, what happened to the last model law when we had all the drafters in situ, physically, it was a marvel to see them. They were actually redrafting certain provisions to assist them draft their laws back home. So if something is not clear or it like obstructs them from actually enacting that particular section, then they would redraft it to assist them to draft it at all in their national legislation. So that's how you should look at it and take it. How will this assist me to actually provide for this particular issue and not be seen to be going ultra virus? So I thought that reminder would be appropriate. Let's look at section 7. Protection from discrimination. Oh, Sutwani, sorry. Yeah. Put on your, yeah.
Yes, thank you. I'm wondering whether we should use the word judicial institution, because we know what we are referring to by a judicial. There's a judicial or quasi-judicial entity, as opposed to saying a judicial institution. I don't know what you meant by judicial institution, but I'm assuming that means a quasi or a judicial or quasi-judicial body, which means it's a court or a tribunal or court or an inquiry situation where an inquiry is done by, for instance, a commission or any other body which has to make a decision on a particular issue.
Committee member, you've heard what the member from Sutwani has said. Please take it up from there. Zimbabwe.
I actually don't have a problem with this judicial institution. I think it's the clearest that could have possibly been proposed. I don't know if there could have been another option, or maybe I'm confining my mind, I don't know, but I tried to figure out what kind of a substitute we would have. And
A body which has to make a decision on a particular issue.
Committee member, you've heard what the member from Sutwani has said. Please take it up from there. I got such a shock. Okay. Swatini.
My follow-up would be that if we accept that terminology, then when you're referring to, for instance, a commission or a commission of inquiry, which is set up for hearing a particular issue and making a decision, and then it's disbanded, would you that qualify as an institution? Because for me, an institution is a body which is standing for the longest time. But for commissions which are just set up, and for tribunals which are just set up and they're ad hoc, you can't refer to those as institutions. Can somebody support me?
Let's take Zimbabwe to follow up, and then Namibia.
My own interpretation was that, like what was put at the top there, you can adapt the definition to suit your circumstance, 1. And 2, for a tribunal, they said you can add definitions to suit your jurisdiction. If you then want to also define a tribunal, you can then define a tribunal according to your preference. But I think the general approach is we are all hoping these go to court and they don't set up tribunals for ad hoc tribunals for daily cases. So I would suggest maybe we keep this, and then when you are now drafting your Eswatini law, you can then add tribunal. We don't use tribunals for this. We use them to investigate officials, misconduct and things like that. We don't use them for day-to-day crimes like this.
Thank you, Zimbabwe. Yes.
Please, let's just read the subsection. Because Zimbabwe is assuming that this is for only criminal cases. But here it says administrative, a decision by an administrative authority or employer.
So, because there's a definition also there. Okay, let's give chance to Namibia. You've left it. So let us look at the two definitions for your purposes. The judicial institution, and remember these definitions are for purposes of this model law. Remember in the beginning, in this model law, we are not talking about yours, but the explanatory note says you can use them and adapt them if you so wish, okay? So it says judicial institution means a court of competent justice or a special court dealing with matters of gender-based violence. So Lesotho, you see your answer is already there, okay, in the definition. So you don't have to worry so much, okay? And then you've got your quasi. You are talking about your quasi-judicial body. Remember, this model law deals not only with the penal aspects, but also the administrative justice, sexual harassment at places of work. So you find there they've normally got quasi-judicial bodies dealing with those matters. Okay, the administrative law will come into play, and we've provided for that as well. So you've got quasi-judicial proceedings, means administrative proceedings that are undertaken for the settlement of specific gender-based violence matters and rights or obligations which may require discretion and decision and which may be the subject to notice and hearing requirements and judicial review. Okay, so you're talking of the whole range of administrative justice. So that's where you're trying. But what Zimbabwe is trying to say, for serious offenses, like a GBV offense, really would you want those to go to an administrative tribunal unless it falls under the administrative justice system, like sexual harassment, which will eventually on appeal go to a court of competent jurisdiction. It will be settled first administratively within an administrative institution and then proceeds to the criminal court system. Are we satisfied? Iswatini? We've dealt with both. Yeah. So when we use judicial institution, we're actually using it in terms of the criminal justice system. Okay. So always bear in mind that we have defined certain terms. So you need to have a reference back to your interpretation section if you are in doubt. Okay. Anything else on section 7? Yes, Namibia?
No, this was a separate question. If we are done with
Yes,
section 7.
yes. But we had to clear
her
mind. It was important. Yeah.
Sorry for taking you back slightly. It's a question that I asked yesterday with reference to early marriage versus child marriage. Is there a distinction? Does it mean the same thing? Because I see that in some there's a
We're going back to the definitions.
Yes, I'm sorry for that. I just noticed that it was actually in the definition. The abundance of caution definition for gender-based violence, which is subclause 3 of section 1. So down, go down. Down.
Or down.
Not up. Yeah. All the way. Yeah, 3 there, sub-paragraph D, which including early marriage.
Forced marriage and female genital.
Is there a specific reason why we refer to early marriage there? Does it mean child marriage? Is it the same thing? Is it two different things? That was my question.
Early marriage is basically, you just have to go back to your definitions when you're doing your thing on all this issue of child marriage, okay? So early marriage is marrying early, before 18. Then child marriage encompasses much more than early marriages. There's so many other components that you deal with when you're talking about child marriage. It's a generic term which will include early marriage.
Mhm.
Yeah.
So for purposes of that definition, we do not want to have the all-encompassing word, which would be child marriage.
I'm not too sure, really. We need to think about it. Huh?
Sorry,
No,
I
she says-
just interjected. I wanted to say, I would think that early marriage is the more encompassing than child marriage.
No, it's the other way around.
Yeah,
It's the
I
other way
understand
around.
that you
But
said it's
for
the other way
harmful
around.
practices, the harmful practice, when you target it, it's the early marriage that is the harmful practice. You understand? The child
But what
marriage
the
is all
definition of a
encompassing.
child?
Huh?
What is the international definition of a child?
18.
18. And
Yeah.
early marriage is under 18.
80, yeah.
So more or less for me, it's the same thing. It's
So the harmful practice itself is
Yeah.
early marriage.
early
So I
marriage.
think that's the
But it's,
appropriate. But when you're talking about
it's a
child marriage, you're talking about early marriage and the limitations and you see, like for other countries, right? They allow them to marry below 18. That's child marriage because their law says that they can marry at 16 with the approval of a judge. So that's child marriages generally, which includes early marriage. It includes, so the harmful practice is the early marriage, whether permitted or not permitted. Anybody below 18, you get married, that early marriage is the harmful practice. So I think it's better when you are doing your legislation because, as I say, some of these standards actually have been given to us by the people who deal with these issues. So it's better you do your own research and make sure that your national laws encompass what you believe would be the appropriate in harmful marriage. Because to me, the harm is actually, harmful practice is early marriage. Okay, let's go back to 7.
Just a typo there with person shall, not just the space between person and shall.
The first, okay, the government come down.
at the end of the
and-
chapter.
Oh, sorry, you mean the space. I don't know why that happens when you change from one application to that. Do you notice they all get stringed up? Huh?
Yeah,
Then you start unstringing.
one of the small difficult issues of drafting.
At first, I would wonder, I said, I don't know, us old people with this technology. Then my IT says, don't worry, this is just an app because you've changed from one to the other. So you just have to separate them. I'm trying to scroll slowly so that you can maybe, if you have any comments. No comments I see. We move to section 8, access to justice. And you notice here, we are restating a human right. Whereas in the part dealing with access to justice, we amplify on the access to justice provisions. And if you recall, I don't want to open a Pandora's box, but I think it's just fair that we all share, and we are all learning from each other. That's why your initial presentations. Zambia made a presentation, I think one of the last persons to make, and she was talking about the State Proceedings Act. And she said they are going ahead to amend the State Proceedings Act so you can actually execute against the government. So if you look at 2, that's why she was stating it, because it relates to subclause 2. So if you do have a State Proceedings Act, please ensure that if it forbids execution against the state, then for purposes of claiming compensation or other remedy that are stipulated in the model law, and if you're going to migrate them into your national laws, that your State Proceedings Acts actually do allow execution against the state. Because I know most Commonwealth countries do have a State Proceedings Act. Is Zambia online? Let's move to 9. I'll take it if it's quiet. Huh? That's what? Or Madagascar? Okay. Madagascar has hand up. Please, can you proceed, Madagascar?
Non, je n'ai pas demandé la parole. Je pense que c'est quelqu'un d'autre.
Okay, thank you. Can you remove your hand? Maybe it was from yesterday. Put down your hand. I'll take it if it's silence, we'll move on quickly. I'm sure you all want to finish quickly. Okay, 9, right to fair trial and settlement of complaints. Oh, she's there, thank you. 10, the right to fair administration. Namibia.
I think subclause 3 reads, a competent authority shall ensure that law enforcement personnel are constantly...
You are in 10 what?
10.3.
10.3, okay.
A competent authority shall ensure that law enforcement personnel are constantly sensitized on the harm corruption and bribery have on victims. Is it have on victims or has on victims?
Harm, corruption, and bribery have participants, has or have, you've got 2 words there. And we just need one, isn't it? We just need one word. Why don't we just use the all-encompassing corruption and remove and bribery? Or does it connote different things in your jurisdictions? Yes, Namibia?
I think corruption is all-encompassing.
I think so. What does the rest of the committee think? Yeah, we just, then we can use has. Okay. Let's move to right to life. 11. Again, I think I've seen something. I hope you don't mind me also. When I'm reading, it's like proofreading for me. Shouldn't we change a court to a judicial institution? Yes. 3, yeah. Okay. Court, wherever court appears, we'll change it to judicial institution. Because I like that issue of special court there. Okay. $12. Yes, socials.
Please.
Okay.
No, with your permission, I was going to take you back to 8.
Pardon?
To 8, section 8, with your permission.
3. We go?
I was going to take you back.
To
8.3.
8.3. Okay.
Yes, it's a bit, it's quite
No problem, no
important.
problem. As long as we get it right.
Yes. Usually, cost follows the losing party. And in this instance, the sub 3, wouldn't you be prejudicing the victim? Should we not instead specify that a judicial institution shall not order any security for cost against a victim only? Otherwise, she will lose out.
Okay, let's get some help from the floor. What Seychelles is actually proposing that we changed it that the security of cost shall not be ordered against the victim. This one is general. It says on matters relating to gender-based violence, meaning there's no security of cost on either party. So can we get some help from you?
No, just to specify against the victim only. Yeah.
The harm that is caused to the victim if security for cost is taken away for both parties?
No, she may be able to bill the losing party for the cost she incurred.
It can be a he, you know.
Yes.
What is the committee saying?
Your legal fees, you can then ask the rich guy some money. Because right now we are making a blanket no. So,
My apologies, Mozambique. I wanted to say that I feel like when we are putting these kinds of, it's not really a benefit, but advantage. For me, it works better for the victim because they didn't even intend to be there. It's somebody else's abuse that has led them to court, right? But then to have a perpetrator also having the costs removed, I feel like it will be really overprescribed. Is it overprescribing or prescribing the wrong way? Maybe I agree with Seychelles to leave it only for the victim. Yeah, then the perpetrator must pay from day one.
Anyone else? Soto.
Okay, no, thank you. You know, I have this attitude that sometimes we should really not really be too harsh on these people, like perpetrators, because I mean, it's like we are condemning them even before we know the outcome, because sometimes we have had instances where actually the people who we claim to be victims have actually just been playing victim, yet they're not necessarily victims. And sometimes we get to hear about that at the end, or maybe after some people have even went to jail. I mean, recently we had the recent case of Bill Cosby from America. You know, some people who go to jail will only be released after some time for things that we thought maybe they did, but you find that they were well orchestrated and we could not really see something. So it's like we're already punishing the suspects, so to say. So I have an attitude against that kind of, you know, strategy being used, because I feel like they still need to be given fair hearing and all that. And because sometimes some of them actually have nothing to their name. They're poor people, and they could find themselves being accused of such. And if you start imposing so much harsh conditions towards them, I think that's if they have done it. But the problem is sometimes people are just accused of something that they did not do. It happens every day, we know.
But Lesotho, when you read it carefully, I'm on your side, all right? When you read it carefully, is it necessary to target a victim? You are lawyers. Remember, I always tell us, we are lawyers first, drafters second. We were trained as lawyers. You can't be a drafter without being a good lawyer, okay? So when you read it very carefully. It says, a judicial institution shall not order any security for costs. You know what security for costs means. It's ordered by the judiciary, okay? On matters relating to gender-based violence. Now, when the statement is put like that, who is the target? Normally, security, of course, is put on who? Huh?
Normally, it will be the victim.
Yes, you are right.
Yeah, because
that's what I'm saying. I'm actually agreeing with you. Do we necessarily have to put victim here?
No, no.
When we know where security, of course, lies in a gender-based violence matter. So do we need to be so obvious and put victim?
No.
Or leave it the way it is, as Lesotho is saying? Yeah.
Lesotho is not saying what you're saying. We are the ones who are saying what you're saying.
No.
He's saying,
you want to put victim here to make it so obvious. And he's saying that because he's a human rights activist, when you are targeting and you want to put victim, you're already accusing him, basically accusing him of having no perpetrator. You are actually accusing him of already having committed the offense. So why just not leave it open?
Okay, so what are security, of course, because this term is not familiar in my jurisdiction.
Security, of course,
in
the court orders it.
Thought, yes.
In case the person who's filing in the matter fails to pay the costs relating to the matter. So the court orders security, of course, and it can be quite high.
We don't have that concept. Right?
Because you are mainly on the civil, you are civil law. But most Commonwealth countries who are sitting around here, they do have security, of course. Yeah.
I need to add to something. I think we should be careful or remind ourselves that this can happen at either stage of the trial or maybe even beyond. Because like at the court of first instance, usually person who will be required to pay cost, security cost will be the victim.
Is the victim.
But then sometimes it could be after conviction and the perpetrator wants to appeal. Yes. Now then it will mean then the burden now goes to the perpetrator to now pay that security. So that's why now I'm saying we should be careful in this.
That we just leave it open like the way it is, instead of trying to target the victim or the perpetrator. Because at any point, and as I said, they can be quite stiff. Security, of course, can be quite stiff. At any one point of the criminal justice system.
Yeah, we don't have that.
So the two of you.
I thought you were talking about totally different costs that are awarded at the end.
I think you were talking of legal fees, right?
No.
Security, of course, means legal fees.
But your assertions is common law.
Usually the cost follows the loser. We are not targeting the victim. I'm protecting the victim. I'm saying the victim shall not be ordered to pay any cost. Yeah. It's the loser who may be ordered, but the victim will never be ordered. You see?
Yes. But you see, Lesotho has played costs, cost, security for costs. That's why it's security for costs, not cost alone, security for costs. will come up at any point in the criminal justice system, any point. And the court has a right to impose the security, of course. And why we are trying to remove it, because it's very stiff.
This is a gender-based one as well.
Ah.
Security for what you are talking about will be true for commercial matters.
No. Even in criminal matters, it can be put in, especially in general. And we've researched this. There's a lot of documentation that where security, of course, have been ordered by the judiciary. And the victim has to put down the security. Yes, read your articles. That's why I'm saying that, please, you should, as drafters, go and understand your subject matter. Read a lot about what GBV is, especially the legislative angles, where it comes to criminal justice systems and administrative systems. Please try to understand it, because here, where we are going now, is we are basically trying to change evidentiality rules. We are trying to change them in this law to persuade you to go back home and change. And you know, as draftsmen, it takes a long time to change common law principles, even constitutional principles. So it's better to start thinking about them. But as long as you understand that law is organic, it's got a function in society. And the function is that it must meet the needs of society at any one point, either to create law and order or to change society attitudes in the way they carry on their affairs. So we are going to change. We have to change, because GBV is a problem, and it has been a problem in prosecutions. How do you prosecute GBV? Even at administrative level, how do you prove? And this beyond reasonable doubt issue, it plays an obstacle in fighting GBV. So in this model, you'll find strange things happening. And the judges, they were very excited over it. That it's high time we change some of these, like the cautionary rule. The cautionary rule was so archaic, and we as Commonwealth countries adopted it from England. England has now changed it. There's no that cautionary rule. They have obliterated it, but we still have it in our systems. But I admire countries like Zimbabwe. Zimbabwe, the courts make decisions as to the needs of society at any one point. And they'll read the constitution in that light. So we go back, they go back to the drawing board and change the evidentiality rules as stated by the highest authority in the land, where it comes to interpretation, which is the judiciary. Please don't mind my voice. I've been speaking, I've been speaking for the past 2 months. So my voice has become very croggy, because I speak from what, 10 to 15 every single day, plus teaching over the weekends and the evenings. So my voice is a bit croggy. I hope you forgive me. So can we move on now, Seychelles? We are satisfied that we can leave it as it is. It's much easier even for you when you come to drafting your national laws.
I actually now understand what Lesotho was saying with the explanation on security costs.
Yeah.
Thank you for that.
Yeah, thank you so much.
I would have misinterpreted it when
Okay. So we were at 11, right to life. Okay, Lesotho.
I have something on number 10,
10.
10.4.
10.4, okay.
I think it is limiting to only say the public officers can only be subjected to a fine. I don't know why is it that we won't include, say, a fine or imprisonment or both. Because I feel like if this offense is only finable before the courts, you can't be imprisoned. Sometimes public officers can actually do this intentionally, because even the perpetrators are behind it, and they're the one who's going to fit this fine, the bill. So sometimes to be serious about it, it should always have an option for imprisonment or even for both. So I would love it to include a fine and imprisonment, not just the fine.
Are we all agreed on that, that we put both? We agreed? Committee members? Yes, okay, please, Rapporteur, imprisonment. Okay, can we move on to 11? Right to life. If I see nothing, I'll move on. Okay, 12, protection from gender-based violence.
Can I just say something? This is just out of concern. Regard to 11.3. Back home, currently, we've just had a string of terrible domestic matters where people have been killing their wives left, right, and center. And it's so disturbing to the extent that currently the people are moving for the death penalty to be brought back. I would have loved it if Botswana was here, because I would really wanted to have their take on this one. So, but by looking at the way things are happening, I'm actually not sure whether, because we're saying GBVs, we should be taken seriously. And can't we leave this to maybe country, the laws of each country, to whether the law death sentence is applicable in their country or not? Because it's the penultimate penalty for them to say, I mean, if you have not been able to be rehabilitated, you just like, this is it, because we've got serial killers and all that. There are people who just prey on women, you know, and sometimes you can feel like these people don't deserve to be living with us. So, I mean, to actually come out and say it shouldn't, are we maybe not limiting, or are states allowed to, maybe when they're domesticating, to not observe this clause? Because that's what, like I said, in Botswana, death penalty, they still implement it. So I'm just worried about that soon. I need to have your take on it.
Even in Zambia, we still impose the death sentence, but the majority, maybe all international human rights instruments actually have against the death sentence. So being a restatement, I've just restated, but most constitutions in Africa still impose the death sentence. So I don't know what you feel as committee members. I know exactly the sentiments. I mean, my partner at my law office, he sits on the Court of Appeal in Lesotho. You know him, eh? Judge Philip Musonda. He sits on the Court of Appeal, and it's interesting to hear what you're saying, because especially as it's the ex-prime minister that has that case, the one who killed the wife. Yeah. So it's
and the irony is actually my uncle.
He's your uncle. There we go. Very sensitive areas. Yeah. So, you know, you really don't know what to do, especially when you're drafting this, because one, you are restating what the international obligation is. And then you find that most of your constitutions still impose the death penalty. So unless you change your constitutions, this won't come to fruition. The model law allows you to progressively reach the gold standard. So I don't know. I really don't know what to say. Zimbabwe?
I think on this one, instead of being silent on the issue, we can just put the gold standard, as you have said, because even for us, we still very much impose the death sentence. I don't even think it's going anywhere anytime soon. And just like with the LGBTQ, Zimbabwe is very strong about that. So it's also about just looking at that domestication clause. You adopt what you can, adapt what you cannot, put on the side what you completely cannot, but at least see the substance the most substantive things that you need. As we progress, perhaps we can make amendments later and then incorporate these issues. But still, I do believe there are instances in drafting where you can put mandatory penalties. Like, for example, okay, I can't go where I was going. It would be focusing on my own country's laws. But don't you have provisions where, like, let's say you put mandatory penalties?
Extenuating circumstances.
Yes, where you say based on extenuating circumstances, the sentence must not go beyond this or what, or even say on this crime, you don't put the death penalty, despite the fact that, yes, we acknowledge the separation of powers doctrine, that the judiciary must have that liberty to decide. But there are instances where you can actually say in this instance, we won't adopt, but of course it will take us back to the policy position, whether they agree with the policy position to not impose the death sentence. But if not, we will have to leave it out, because for us, we still have the death sentence.
Have you received? You didn't say it. They send you a message. You didn't say yes. Okay, so I think we leave it as a gold standard. Okay, so let's go back to 12, protection from gender-based violence. Yes, please, I've gone back to my nonsense now. Eswatini, yeah. Yes, please.
In 12:2. I don't know why we are saying a woman and a child and leave out the others again. Because the topic, the heading is protection from GBV. So for me, protection covers or relates to any person.
Committee,
And
please,
also-
when someone raises an issue, just jump in, whoever wants to comment on it.
Oh,
Yeah.
and also 3, can I also have 3 attended to? Because it talks only of women, yet the acts that are referred to include also the other persons.
Yes, Lesotho.
I think I support the sentiments of my colleague, Mr. Ogo, because it's known that, of course, women and children are usually the most ones that usually suffers this kind of offenses or violations. But although rare, men sometimes also do suffer. So I think it's only prudent that we also include even men and to also be protected against this kind of violence. Although it minimally happens, but back home, the reason why it doesn't happen is because the police officers will laugh at you forever. You just can't go to them and complain and say woman wanted to have a sexual act with you. I mean, it's like a taboo. So yeah, on the ground, it's difficult to report such cases as a male. But as a gold standard, I think we should also try to protect both men and women on this one. So I think I support her sentiments that maybe we include another gender. Thank you.
Okay, can we maybe delete 2 because they've already covered in a person? It's exactly the same wording. Okay. And then we move the marginal, the footnote into 1, because it refers also to 1. Those are my suggestions, but I would urge you to keep 3 as it is, because it's targeted at specific sexual offenses relating to women. So Iswatini, are we okay if we delete 2 and we retain 3? Because this is a particular concern amongst the advocacy groups relating to GBV. And this was actually provided as it is from those groups.
But if I may ask, is it because they imply that this kind of violations are never done against male counterparts?
They are mainly targeted at women. There's very few cases where women have the right to refuse sexual acts, where the men actually have the right to refuse sexual acts. You understand? So the 99.9% of the cases relate to women.
I understand what you're saying, but I beg to differ with them because, like I said, there are official statistics and there are unofficial statistics, that is unreported cases. So the challenge with male people is that mostly that there are violations, they never report them for different reasons. Like I said, in my country, you never hear the end of it, and for other reasons. So you are considered like a weak man to be refusing such, but it actually happens. You know, if you take incidents of the house helpers, the domestic workers, some of them usually even take advantage of our young boys at home. They sexually abuse them and all that. So, you know, to go in a gold standard, I mean, and to just ignore that such a thing happens, no matter at what scale it does, but it happens. So I'm saying I appreciate that women are actually the ones that suffer most of these violations. But I'm saying, can we say if it's only 2% of men, so we should just not say anything about those 2%? That's where my concern is. Thank you.
I can assist possibly with a recommendation. You know how the trafficking in persons is worded? They protect people from trafficking in persons, but then they say especially women and children because they are the more vulnerable group. So perhaps it can be, the provision can be designed in such a way that when we say no person, and then you say especially women and children. And then these 3, I feel like we can still sort of keep it. Perhaps we can have the 3 and a 4 being general relating to the same act, and then if a 3 being general, then a 4 being that current 3. If it makes sense, or if you feel it's duplication, we can find another way.
So what you are proposing is a generalized wording.
A generalized wording, but we still say especially women and children. Like the way it is in the trafficking in persons, we acknowledge that trafficking happens to everybody, but we do highlight the vulnerable group.
So you are saying something like, I'm not supposed to be drafting for you, you're supposed to do your own drafting. Huh? But I'll try and assist you here. But please, when you propose, Esutani, please, when you suggest, propose a redraft. Because otherwise we will not finish. So let me try to do it.
We can say every person.
Yes.
Sorry, before you do it,
Okay.
I think 6 covers the especially women and children.
Just let me just finish doing this so that you can be satisfied that it's generalized. So that's generalized. So the first is generalized. The second, so we'll put no, that one there we've said, remember we said we'll delete. Remember we said we'll delete 2. So we delete this because we've included it in there. And then this one we have generalized. And then
6 goes into detail.
don't worry about the
about,
numbering, we
measures
shall
and so
do the
forth.
numbering.
Perhaps they're sort of not necessarily directly related to
Yeah,
the.
so remember
thank you,
also
SADC.
this law, although we generalize some of the provisions, we must also be seen to be targeting special provisions related to women. Otherwise, we are going to be in problems with the civil society organizations. So we may generalize maybe the top things, but when it comes to special policies and special measures, we actually try to target certain groups. So I don't know whether you want to actually change 6.
It's fine.
Yeah.
6 is fine.
Yeah. Okay. Let's go to 13. Fourteen. Any comments?
Okay, for 14.5.
14.5.
I mean, I don't have a problem with it, but I feel like it is sort of an example. Like this kind of incidences can happen at different setups. So I'm not sure whether it's wise to actually like to have now went for the issue of residency alone, singling it out, or whether it's possible to have a general clause that maybe just covers every other incident, because I think it might happen not just where there's a tenancy agreement involved, but so many other situations. Sometimes even at school, sometimes you find that people can just expel your child from school for maybe related to this kind of GBV offenses that have been done or something. And I feel like it's like here we just went to specifically that, but instead we should rather have a general provision so that it covers even other incidents separate from the tenancy one. It's just a suggestion.
I'm losing my draftsman. Yes, members of the committee, you've heard Lesotho. Please, can we discuss that and see what we can do with that provision? Have we heard what Lesotho has said? That it could be for some other reasons not related to the GBV, isn't it? Yeah. So please, can we comment on that? Because we have to go away from here with consensus, at least on some provisions. Mauritius, you are too quiet for us.
I think any order that is made might be subject to an abuse by any person. But it's up to the court to determine whether there has been enough evidence brought in to show that the breaking of a lease is linked to gender-based violence. I would recommend that it stays here. Because at the end of the day, the court would have to determine whether there's enough circumstances. We're just giving the court the means to do that.
Okay, can I maybe try to
Yeah.
clarify my concern?
Mhm.
You know, sometimes you can have a child attending a school A, and then sexual offenses maybe, or some GBVH offenses her rights are being violated. And sometimes you might even need to change your child from school A to school B. Or sometimes even at work, you can be subjected to these kind of things. And maybe you say you demand a transfer, especially if you're working for the ministry, for the government, and say, no, a trafficking department, I feel like maybe I need to go and join a different department because I've been subjected to this and all that. So I'm just trying to say this GBV things can just happen at almost any scenario. So to single out the tendency one, I'm not saying a tendency that it cannot happen, but I'm saying to single it out, it's like with these other possible other scenarios, then we are saying, no, we are excluding them. Because remember the exclusion rule, the mentioning of one, you know, so that's why I'm saying, can't we just have a general provision that maybe just shows or it gives victims rights when they have been violated against, regardless of whether it's in the tenancy agreement or at school environment or even at work or, you know, things like that.
Okay, most of these, let me also just give you a little guidance. So most of these issues that are appearing under equality privacy are actually from the UN legislative guide on gender-based violence. They've basically been lifted from that legislative guide of the UN that was agreed upon by an expert panel. They had constituted a committee and they came up with a legislative guide. That's one of the research materials I've actually indicated in the model law for you to go and look at. I think if you look at that, you understand why Mauritius is saying she rather leaves it in, because it's one of the principal items appearing in the legislative guide relating to actually rental premises. Rental premises. It actually appears just as it is there.
If I can assist my friend any further, when you're subjected to gender-based violence, one of the basic things that you need is a house.
Yeah.
And if you can't move out of your house, then that makes it very difficult. And if you have to pay extra for the penalty for breaking a lease, that makes it very difficult for you to move on with your
That's
life.
what the UN says.
I think that's why
It's one of the
should stay.
major issues.
Others are, well, maybe less important, like moving houses and moving employment or moving school. But the house is what you need at that point in time.
And that's what the panel
I'll just
of
let it
experts
slide.
actually stated.
Not that I'm
exactly what you say.
Not that I'm convinced or agree with it,
Yeah.
but I'll let it slide. I'll just okay. No,
Anyway,
it's
it's
fine.
a gold standard.
Yeah.
And when you're coming to your own legislation, you'll be able to see how best you can deal with it. Okay. If you want to amplify the entitlements, then please do amplify the entitlements of other areas that they may need not to be penalized under. Is that okay, Lesotho? Yeah. Okay. Let's move on then to 15. Remember, we've still got quite a number of pages, over 100 pages to finish by 15 hours today. So I hope you have all annotated the areas where you want to see an amendment, so we go faster. 15, access to information. 16, non-refoulement of refugees and asylum seekers. Seventeen, protection from harmful practices. Pardon? Uh-huh. The minister shall put in place policy and special measures to ensure that women and girls are not subjected to harmful, okay? Eighteen, right to education and access to educational facilities.
17 sub 5, perhaps we should also consider commits an offense and shall be liable on conviction to a fine or imprisonment not exceeding.
Okay. 18, right to education and access to educational facilities. Nineteen, right to health. There's a hand? Oh, sorry, Mozambique, please go ahead.
No direito à saúde, no número 2, F, eu acho que está um pouco ambíguo quando dissemos a abolição de práticas prejudiciais. Se estamos a falar da saúde, talvez pudéssemos acrescer a abolição de práticas prejudiciais à saúde. F.
Where are you exactly? You're at 19.
Abolição de práticas.
19, which subclause?
3, F.
3.
Yeah. No,
Subclause
4 F.
4. The minister responsible for health shall.
F.
Yeah. Policies, measures, strategies, women, access to health and medical Which one exactly? BC?
Abolição de práticas prejudiciais. Talvez fôssemos acrescentar abolição de práticas F.
Okay, F. F.
Yes.
Ah.
Abolição de práticas prejudiciais à saúde, para completar. Parece que está um pouco ambíguo. Quando... Estamos a falar de direito à saúde. Não sei.
Okay, thank you very much. Can we have Zimbabwe and then Namibia in answer to this?
I don't know if my point is still valid after the further explanation that she gave, but I thought she was saying, initially I thought she was saying we are not clear what the harmful practices are.
Yeah.
And I wanted to say, but it's defined. Harmful practice is defined to include harm that threatens a person's health. So the definition of harmful practice is adequate. But then in the second explanation, it was as if she was saying, let's separate, let's be specific to which harmful practice we are referring to. And they are harmful, and then she's saying harmful practice in relation to health. Is that what
it's the
you're
same
saying?
thing, because harmful
Yeah, because
practices
it's already
is already defined, and
to include
harmful, it must be
all-
harmful to
Yeah,
your health.
it's physical, psychological, everything.
Zimbabwe, Namibia, that's what you wanted to say? Or you wanted to add anything more? So, Madam from Mozambique, if you look at the definition of harmful practices, it actually connotes that it's anything that would harm your well-being or your health direction, whether it's sexual reproductive rights, fistula, all those issues. So you have to go back to the definition of harmful practices. So since it's a defined term, I don't need to re-explain what harmful practices means. Are we clear, Mozambique? Okay, thank you very much.
I have a question.
Yeah.
19.3.
19.3.
I just wanted clarity on that one because it looks like it refers to different scenarios. That is, there's a position where the government is obliged to offer health and nutrition services. But then the first instance, I just want to know, because the first one that says a woman and a child have the right to receive adequate nutrition and health services. I want to know in that one, who is the person being, the obligation is being directed to?
Pardon, the last sentence?
The first part, who are we directing the obligation to offer these women adequate nutrition and health? Yes, there is, because it looks like there is a second part to it, where then the obligation is on the government.
Yeah.
But then on the first one, who has the obligation to give them adequate nutrition? And
it's connected to the second part.
Yeah,
because the first part is the restatement of the right, and the second part is, and where such services are provided by the government shall.
It's because that.
So there's
me
the
implies
family,
that-
remember, nutrition and health, the family
Yeah.
comes in. Yeah.
So basically, the first scenario will be, where is the family who has provided, who is providing?
Yeah, it's just a restatement of the right under international treaties. It's a restatement. And then, but where the government is actually providing for it, it must be adequate.
That one I understand.
Yeah.
Where the government.
Yeah.
I had a problem with.
Yeah, the first one is just a restatement. That's all it is. It's a restatement of the right as appearing in international agreements.
Okay.
Yeah, that's all it is. Okay, we are nearing tea now. Maybe we break now. Can we break for tea now? And we come back and go to the right 20, the right to employment. Yeah, we are very slow. Okay.
So we can come back at 11:15. Take a 15 minutes break. Thank you. Tea is served at the same place that we had it yesterday.
You're worried about your.
I
keep seeing him looking at his phone. Mama,
We don't know
whether they accurate. You see us who went to go and pay my 1.5.
no more.
3 negative. You see, let me show you mine so that you can know what it looks like. Yeah, ungaseke but this is the one you received also.
Yes. Can you calculate it? Because this one, anywhere in the world they can check. This is the once it doesn't have this one.
You see?
What do they call it?
The
QR
code.
code. Yeah. So it's coded, it's an international system. So once they get that, they can go
You
to
got
the
it.
database if they need to check.
You haven't got it. But this is the Welcome back. Ladies and gentlemen, may we proceed now? We are doing okay. We are on page 78 of a 147-page document. We need to finish today. So let's see how fast we can go or how efficient we can conduct business. Okay. So 20 is right to employment and social security. Again, restatements with some policy points included.
S'il vous plaît, j'aurais une question avant qu'on ne puisse passer à la section suivante. Toujours, je peux prendre la parole? Pardon. J'ai levé la main, mais vous n'avez pas vu. D'accord.
Please go ahead.
D'accord. Alors, toujours à la section droit à la santé, 19G, c'est écrit de savoir quelles informations ont été recueillies sur leur santé et d'avoir accès à ces informations, y compris à leur dossier médical. J'aurais une question par rapport à cette phrase. Dans le cas d'un mineur ou d'une... D'accord.
Yeah, please proceed.
D'accord.
Proceed.
À la section 19G, la phrase G, dans le cas d'un mineur ou d'une victime qui est devenue inapte à s'exprimer, est-ce que leurs proches auraient accès à ces informations ou à ces dossiers? C'est juste un questionnement que je me pose en fait.
Okay. We are just being assisted here to share.
Attendez. 19.2G. Droit à la santé.
G. Yes, I can see it. Members of the committee, please, can you respond?
Sorry, can you perhaps repeat the question?
Madam, your members are asking if you can repeat your question. They're not really clear as to the extent of the question.
Oui, je suis toujours là. Non, justement, c'est vraiment une question que je me pose à moi-même parce que si c'est le cas, si effectivement... Ah, d'accord. Dans le cas d'un mineur ou d'une victime qui est devenue inapte à s'exprimer, est-ce que leurs proches, c'est-à-dire leur famille ou je ne sais pas, une autorité de tutelle, auront accès à ces informations ou à ces dossiers médicaux?
Are you now clear as to the question?
Yes.
The right is stated as having, you read it from the top, the health rights of women include being entitled to information, that's knowing what information has been collected about their health and having access to this information, including their medical records. She's asking whether the next of kin can collect on behalf of a minor. Remember also, this is just a restatement and the details relating to that will come later.
Exactement. Parce que là, en fait, il parle d'avoir accès aux informations médicales, y compris au dossier médical. Et justement, si l'enfant est mineur ou si une victime est justement devenue inapte à s'exprimer, est-ce que quelqu'un d'autre, à part eux-mêmes, peuvent avoir accès à ces dossiers médicaux?
Yes, they will be able to, and that will be provided in your national laws. What we have done in the one you have just quoted, and basically the whole of the right to health, is a restatement of the rights and privileges. It's a restatement. So we are not looking at the action that will be found elsewhere. Are we
D'accord.
clear?
Oui, oui, c'est bon, c'est clair.
Thank you, thank you. Anything else here? Yes, Eswatini. $18. Please, can we pay attention and follow the numbering? Otherwise, we'll be going backwards and forwards and we won't finish. We've only got up to basically 15 hours.
Okay, I thought you.
Yeah,
was
so,
on the
okay,
same-
let's try to be efficient. So it's 18 what?
G,
G,
4G.
4G.
Yes, I note that there's reference to care providers, yet we defined caregiver. Is it the same? Or it's just a matter of putting giver there for purposes of consistency?
What is the question? It's not clear.
4G provides that it reads preventing sexual abuse of
I think
women.
for your
and-
question, I think read it from the top so that you are clear. Read it from the chapeau.
It says that the minister responsible for education shall, in consultation with the minister responsible for gender and child development, put in place special measures. Can I just go? By A up to G, and then there in G it says that by preventing sexual abuse of women and girls by teachers, care providers. And my question, my concern is that it's not consistent now, because in the definition we defined, in the interpretation section, we defined caregiver as opposed to care provider. So I am saying we should change care provider to caregiver in this paragraph.
Okay, so you are referring to what the defined term is. Okay, we shall look into that. Because I know we could probably by error have been interchanging the words. So we'll check throughout the document, okay? So we don't have to raise it again. We'll do a quick check when we are proofreading. Thank you for that. Let's go back to 19, which I think we've completed. We were on the 20, the right to employment and social security.
On 20, sub 4, it reads, a victim who has been harmed as a consequence of gender-based violence, whether at the workplace or elsewhere, is entitled to take paid leave of absence of up to 15 days in addition to other paid leave. Does this provision then mean that you should declare that that specific leave is for the purposes of being a victim of gender-based violence?
Yeah, definitely. It has to be connected with the gender-based violence offense that you have encountered or be subjected to.
Is this consistent with,
Yeah.
the right to
You see,
privacy?
who
and
has
not-
been harmed? That's the modifier.
Yeah.
A person, the modifier is a victim who has been harmed as a consequences of gender-based violence, whether at the workplace or is entitled to take paid leave. Okay. So the modifier is who has been harmed. So it's not all victims. Maybe there's no harm, it was maybe psychological, but even psychological. If she's so depressed or he's so depressed as to be unable even to concentrate at work. So in most cases, you find they'll need a medical report.
When you are, applying for this special leave, do you have to indicate that it is because I have been a victim of?
Yeah, and they'll ask you to produce a medical report, most probably, most jurisdictions anyway.
Your employer?
Yes, your employer.
Okay. In ours, you don't have to declare, your illness
That's
or
when
your
your law is-
condition.
So your law is more relaxed. That she just says, I'm subject to gender-based violence, and she can take her 14 days. You've got a more relaxed law. But the harm of having such a law is that they'll just be misusing it. Yeah. It will be misused. Yes, Eswatini.
I'm thinking of a situation in relation to this one where the person is a victim because a minor child has been affected by GBV and the person has to go and take care of the kid. For instance, where...
Can you talk in your micro? Yeah.
Oh, sorry. I'm thinking what happens in a situation where the victim, the person who is at work is affected by GBV at home and they have to take care of a minor child who has been injured, or where the crime was perpetrated against a minor child and the mother has to attend to the child.
Yeah, committee members, you've heard the question.
Okay, can I say something?
Yeah.
I think usually under labor law, but it's usually an allowed excuse or reason for a parent to obtain any form of leave, like even a sick leave, you can just obtain if your child maybe is hospitalized and this is still a minor child. It doesn't necessarily have to be yourself who is injured, but if you can be able to show that it's you who has to take care of that minor child, usually you have to qualify to be given such a leave. So I think even with this one, it means if your child is a victim of GBV, then automatically your employer should be able to release you because you're going to take care of a victim of GBV. So I think for me, I think it should apply that way.
Yeah.
Yes, thank you.
And obviously the mother would be psychologically affected. And that's a component of GBV, a psychological, emotional, all those. If she's the victim, or if it's the father is also psychologically or emotionally affected. They can apply. It's the victim. Okay. Let us move on.
Sorry. Zimbabwe.
Zimbabwe.
Before you move on, just to go back to the top, I stand guided, but do we have a right to employment? I thought we have a right to fair labor practices, yes, but not the right to actual employment.
Mm-hmm. Everyone has a right to employment under the economic convention, as long as, you are qualified and blah, blah, with all those things. Yeah.
Hmm,
But
I wasn't
employment
aware.
can mean even she's got a right to go and dig up her fields
Okay.
and things like that. These are the economic rights now,
Okay.
which most of your constitutions have not yet embraced. You mostly deal with civil and political rights.
Yeah.
But the economic and social rights are lacking in most of your constitutions, except for those who have got modern constitutions. You find they have embraced those. Zambia is only now going into another constitutional reform where now we are going to bring in all the economic and social rights. Yeah.
So the
But
import
this
of,
is a restatement. It's the gold standard.
yeah, I agree.
Always keep that in mind.
Yes, I do.
So it doesn't mirror your own constitutions. We looked at your constitutions and we saw some of you don't have these. So progressively, when you come to your reviews, you may want to include some of the economic and social rights.
Okay. Okay, so this is an action that I can bring against the government if I'm not employed.
What's that?
This right.
Pardon?
This right. So I'm saying in terms of the new and
Oh, have you?
emerging
Okay,
rights,
maybe you haven't read.
I haven't read about
You haven't,
this
yeah, you
particular
haven't
one.
read how you deal with economic and social rights, right? They are derogations, quite a number of them,
Okay.
either in terms of financial, in terms of lacking the educational capacity to carry on certain professions. So if you
Okay.
look at the conventions themselves and the write-ups of the committees, they'll actually expand and amplify the derogations and why they exist. So you just need to read around human rights.
Okay.
Yeah. So if you look even at the constitutions of those who have these, I know we had a draft and I drafted them. So there's many qualifications in relation to economic and social rights. The major ones being government needs to show that it does not have adequate financial capacity to provide that right at that time, but they are progressively achieved within society.
Okay.
Yeah. So be careful with the civil and political rights. Those, they've got less derogations, whereas the economic and social rights have much more derogations.
Oh, so that's how they are differentiated. I
Yeah.
was feeling like they are harder to enforce, but I get. your
But when you state
explanation.
them, you state them like that, and then obviously it follows what follows.
Yeah. Okay, thank you for that insight.
Okay. Uh, 21, right to nationality. Some of these are the newer rights which are coming on the block, which were never contained in the civil and political rights that you know of. So as you know, human rights is an evolving phenomena. And every so often you find a new right actually pops up. Okay. Rights to asylum. (23) Protection from exploitation and right to sustainable livelihood and empowerment. 24, rights of vulnerable women and children. '25, special policies and programs for victims and women living in rural and peri-urban areas. Zimbabwe, you may want to know that your MP, was the MP in our consultative process, was very, very concerned and was hoping to see a provision in relating to this particular issue. Because she says that you've got a lot of problems in rural and peri-urban areas, which need special attention, especially in relation to the women and traditional leaders in those areas. So she was happy when this was pointed out to her. '26, general policy direction for achieving human rights. Moçambique.
Eu tenho uma preocupação em relação à linha G, quando diz que o governo deve desenvolver diretrizes e implementar planos estratégicos para disponibilizar apoio adequado aos filhos das vítimas. A minha preocupação é a seguinte, é que nessa situação de violência contra o gênero, não só os filhos é que são dependentes das vítimas. Há situações em que os avós tomam conta dos seus netos, porque os pais dos filhos...
Which section are you reading?
26.
26.
1H.
26, 1G, okay. Yeah.
A minha preocupação é que eu acho que nós devíamos acrescentar, disponibilizar apoio adequado aos filhos e dependentes das vítimas, porque não são só os filhos que são dependentes das vítimas. Há situações em que os avós ou outros parentes tomam conta de pessoas que não são seus filhos. Há um caso que sucedeu em Moçambique, por exemplo, que uma senhora era empregada doméstica, mas ela tomava conta dos seus netos, porque a mãe estava morta. Ela sofreu violência por parte do seu patrão. Ficou incapacitada, já não podia trabalhar. Então, os seus filhos, os seus netos, nesse caso que estavam sob dependência, já não tinham proteção. Não tinha quem tomava conta, quem devia dar comida, como ir à escola. Então, eu acho que aqui tinha que se alargar o campo, não só os filhos, mas talvez se dissesse e seus dependentes. Disponibilizar apoio adequado aos dependentes das vítimas. Obrigada.
Committee members, there's a suggestion that we add independence. I've highlighted it there. Pardon?
I think perhaps relevant, dependent.
Relevant.
Not all. I'm worried about the budget.
I know. It's going to be so huge. Members of the committee? Other members, please, can you make a comment on this?
I suggest,
Yes, Swatini.
we use affected, not relevant.
Then we have to define what appropriate dependence mean.
Or maybe we leave it to the maybe subsidiary law to unpack it.
Pardon?
I'm saying maybe we leave it to the subsidiary law to unpack it. Yeah. Some instances it's grandparents, some instances it's an aunt.
Through the chair.
Yes, yes.
Hello?
Yes.
I think that the national laws should be able to guide you on this particular matter, because I think the different countries have definitions and different pieces of legislation that depicts what a dependent constitutes. So it's not something that you would want to elaborate in this model law. I think it boils down to what you have considered as a SADC member state to what definition you've given to the term dependent. For instance, for us, we have the term in the intestate succession laws, we have them in the pension laws. So it's really what you assign a dependent to be in your national laws. I thank you.
Yes, thank you, Walia.
In
Zimbabwe?
hindsight, now that I'm applying my mind a little more, I'm now beginning to wonder if we need to add dependence, because the parent is alive, right? They're just a victim of gender-based violence here. So we are trying to make sure there's adequate support to the child who is...
They could be dead, you know. The parents could be dead. They
in an
even killed
instance,
themselves, both of them.
So this support is for the child, right?
Yeah. Here
Would
you are
it not be
targeting the
adequate
children
to
and
say
dependents.
child? Because in my mind, and I could be wrong, in my mind, I'm thinking, if I go and I now live with Namibia, the support that is for me is enough for this person to be able to take care of me. If we include this person, does it mean we must now also support their needs?
You know, there's so many scenarios in Zimbabwe.
Okay.
This says it's targeting now the children. This is not targeting the victim.
Yeah.
If you read it, providing adequate support to the children and dependents of the victims. Yeah. Okay. So a scenario could be the wife, because of gender-based violence, she lives, as you said, she's staying with Lesotho. Then the states must look at, there's other provisions where they look at you since you're still alive, and your children and your dependents. There's another scenario where you could have died and your children have been abandoned. And your husband could be in jail. So they have to look after them. There's so many scenarios that can actually arise due to GBV, which affect the children directly and the dependents. You understand? Yeah. They could be in care, they could be with a grandmother, they could be with an aunt, but we are targeting the children wherever they be, as long as they are a product of GBV. They have to be looked after. So if you look at the preventative and protection measures later on, they amplify these provisions where we have restated the rights and have provided a policy direction, because this is the only part that you'll see the policy directions coming in. The other parts, they are merely action points that they must do this, they must provide legal aid, they must provide this. You know, it's like action points that have to be done. But these are all policy direction, okay, which you shall develop further in your national jurisdictions. Okay, yes, Lesotho.
Okay, no, thank you very much. I think the way it's been written or suggested there, it actually, it loses what is the issue. Because I think the issue is if a child who is staying with the parents are victims of GBV, the state should do something to support those children. So it could happen that some children are now being taken care of by guardians or something. And the violence of GBV is happened to those guardians. I think it also should mean even those children who are staying with a guardian who has suffered GBV should also be taken care of.
Different scenarios.
Exactly. But it's just that dependence, the way now it's written here, it looks like we are saying the groups that have to be taken care of is the children and dependents. Yet I don't think that's what it needed. I think this provision only wanted to target the children. So what is different could be whether the children were staying with a victim who is their real parent or who is their foster parent or who is their guardian or anything. But at the end of the day is because children are staying with somebody who has suffered GBV, those children, there should be a sort of support system for them. I think that's what this provision wanted to achieve. So if we suggest to add dependence this way, to me, it's like it is actually changing what the provision intended to do. I don't even see it as amplifying it. It seems like now we are changing it. I don't know if everybody follows what I'm saying. Thank you.
Can we have a reaction from Mozambique?
We do, and I propose it be deleted.
Okay, Zambia proposes it be deleted. Mozambique. There's a proposal on the floor that you don't actually need to add the and dependents because the provision itself was targeting children. And the children could mean even foster children.
Problema da tradução, porque o que eu tenho aqui é disponibilizar apoio adequado aos filhos das vítimas. Quando dizem aos filhos das vítimas, é como se estivessem a dizer, se eu sou vítima da violência, é como se estivessem a dizer dos meus filhos. Não estão a dizer das crianças. Talvez se estivessem a dizer das crianças, eu ia perceber que são menores, precisam de assistência. Agora, quando dizem que são dos filhos das vítimas, há situações, eu estava a dizer, há situações, houve um caso que foi reportado de uma senhora idosa que estava a cuidar dos seus netos, porque os pais já não tinham pais. Ela era empregada doméstica. O patrão violentou-lhe, bateu-lhe, ela ficou desfigurada, já não estava em condições de trabalhar. Mas ela ia trabalhar e era para sustentar aquelas crianças. E como é que ficam? Se nós dissemos dos filhos das vítimas, vamos entender que aquela senhora, aquela velha que foi violentada, era mãe, passou a ser mãe dessa criança. Eu acho que aqui talvez o problema é a tradução. Porque aqui no meu documento vem filhos das vítimas. Esta situação de violência doméstica vai muito para além das crianças. Há pessoas vulneráveis. Mas tá bom, eu vou concordar se...
If I may say something.
I think she's brought in another point, which is also a valid point for consideration. She's actually stating, and now I think she's moved away from her dependents, okay? She is saying that we should not add the word of the victims or something like that, if I'm understanding her. Because these children, no matter where they are, but I'm not understanding her clearly, because she's saying they shouldn't be the children of the victims.
Can I say something?
Because if they are staying with their grandmother, and the grandmother is a victim of GBV, those children are not hers, they're her grandchildren. So she has broadened it. She's brought in another aspect which we have not considered. And I think it's a valid point.
I have something to say.
Yeah.
It's because I think my point was, by children, we should not only restrict ourselves to biological children. That's why I said there could be even foster children. It could just be a guardian, because usually where the parents have died, the person who left in the care of the children will be a guardian. And whether that guardian is the grandmother or what, that person is a guardian. And it means then that if something happens to a guardian, those children should also be protected. So who the people we are protecting here is the children, because the guardian will be playing a parental role to those children, this person who is now suffering a GBV violation. So I'm saying, whatever we suggest, let's not try to protect the guardian, but we keep the protection with the children. So whether they are staying with the biological parents or with the foster parents or they are just guardians because they are grandmothers or whatever, but if something happens to those group of people, then the children there should be a support system for the children. Yes, that's what I'm saying. We should be careful not to move away the spirit of that provision, because that's what it wants to achieve. But I understand you should not restrict it to only biological children, like only those children that are actually yours alone. Thank you.
Obrigada. Acho que é uma questão de tradução. Traduzido de inglês para português já fica com outro sentido, mas depois da explicação eu já pude perceber que é mais abrangente. A minha preocupação é que parecia estar restritivo, mas agora já percebi. Obrigada.
I think we need to give it a little bit more thought. I tend to agree with Mozambique. There's something wrong here, because these children, it doesn't matter if they're the children of the victim, because even the grandmother, the auntie, can be a subject of GBV, and she's looking after these children, but they're not her children. They are nephews, nieces, grandchildren, and so forth. So I think we need to redraft this provision. If you can trust me, I've highlighted it, and I agree with Mozambique. So I'll not do it. Okay. I'll relook at it and try to ensure that it encompasses the points that she's raised. I think they're very important. Is that okay?
Yes, it's okay.
Mozambique? Thank you.
I was actually only wanting to suggest that maybe we can insert children under their care. But since you said
that's what I want to.
Yeah, you can.
That's what I want to do. I was going to put something like this. So I was going to do something like that. So I'm not saying this is the final draft, but it was going to be something like this: providing adequate support to children under the care of a victim. And we will define children to include dependents, foster children, blah, 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 blah. We'll use the same definition of children as we used in the model law on child marriages and eradicating children already in marriage, because that has already been adopted. Is that okay, Mozambique? Something like this? Okay. Let us proceed now to part 3. access to justice and procedural protections. 27, general requirements on access to justice and fair treatment.
Excuse me, one more. Just to clarify, 27.1, provided with all support for him or her to regain control. If we ask control of what?
Tell me, you are in the first victim shall be 1.
27.1.
Yeah.
If we instead say him or her to regain socio and economic stability.
Where are you suggesting? Just read it,
Okay.
what you are saying.
Okay, a victim shall be treated with compassion and provided with all support for him or her to regain stability or socio-economic stability. Because if you say control of
to regain control. You want to add that what?
To regain social and economic stability.
Okay, have you heard Seychelles' point? He wants to add after to gain control of socio-economic stability. That's what he wants to add. Can we have comments from the rest of the team? Zambia, have you got the point? I think you're the only one online. Seychelles wants to add after control, social and economic stability. Or Madagascar as well. Yeah.
Or instead of the word control, we substitute it with socio-economic stability. Yes, but the first section is general. It's just a general statement.
Sorry, Mazumi. I think it should be directly related to the needs under access to justice and fair treatment in the court process, in the access to justice process, sorry. But however, I don't understand, it's like it's hanging when we say regain control and then we leave it there. We mean control of what here? Of their life.
I think, yeah, their life, or to recover from the effects of gender-based violence. Maybe we should state it in full.
Yeah.
For him or her to recover from the effects of the gender-based violence. Yeah.
Yes, because that point I agree with, because even if you look at other laws related to, for example, maybe trafficking in persons and so forth, they even have a grace period before they start court processes, where they say it's some call it a reflection period, some call it a recovery period, so that at least your mind is in the right place when you start these processes, or at least your mind is near the right place, near enough to be.
Chair.
Someone on the floor.
Yeah, please proceed, Israel.
Can I
think
there's someone. Okay, can I talk to
I agree with the proposal by Zimbabwe. Hello?
Yes, we are listening. Please proceed.
Oh, okay. I agree with the proposal by Zimbabwe because I think this is more a psychological issue as opposed to social and economic standing of the victim. It's really to allow you to regain your composure as you are in this arena of provision of access to justice. It's not really the aftermath, but what is your state at the time that you're before these judicial institutions? So I think the qualification that has been made by Zimbabwe is acceptable. I think.
Thank you. So we are going to delete regain control and add it to recover from the gender-based violence. Is that okay, Seychelles? Okay, let's move on.
Can I come in?
Eswatini.
I have a problem with the terminology we are using, because in a case where the person has permanent like physical or mental disability, when do you say that person has recovered from the effects or from gender-based violence?
Have you heard the question? What if there's a physical injury? When do you say they have recovered?
I agree with the point that she's raising. However, I don't know if this is the place. Perhaps the wording sounds insensitive to the situation that she's speaking of. So maybe we can just be clear that for this one, it's like the recovery period that I'm referring to under trafficking in persons law. It's just to try and put this person in a reasonably better mental state to be able to take on the legal processes that happen afterwards. So it's not really intended to mean we're waiting for 2 years until you're psychologically okay, or we're waiting until all your physical wounds have healed, because that would be unachievable. I think we're just trying to make sure that this person is in the right mindset to at least be able to deal with this, because the shock of this, the trauma of suffering violence from a close person, for example, in domestic violence, is not something that we would expect someone to just get into a shelter and start going to court. We don't want to ignore that point, that this person still needs time to recover. So maybe if you feel the language is insensitive, you can maybe give us better
this is
language.
only the way you treat the person.
Yeah.
It's just saying treat them with compassion.
That
There's nothing more
victim-centered
to it.
approach.
Just treat them with compassion, that's all. You are not actually giving a privilege in. You are stating an approach. How do you treat a person who has just been subjected to gender-based violence? So they're saying treat them with compassion. Maybe you're overreading it.
Maybe, it's okay.
Yeah,
Let's
I think you're overreading it. Okay, let's move. We're already getting into lunchtime and we haven't done anything after tea. Anything else on 27? Pardon? Okay, 27. The general requirements, these are very general in nature, and some may be amplified later. What you call an alert provision. Can we go to 28, general provisions on victims' entitlements and access to legal services? Again, general provisions which can be amplified individually later. Any comments or changes you want to make on 28? I see none. Let's go to 29. Hearings not in open court. I see none. Let's move to 30, injunctions or other orders. I see no hand up. 31, intervention orders. Okay, I see none. Section 32, restitution. Section 33, financial assistance from government.
May I ask something, please? Sorry to delay
what
you.
section? Lesotho?
I'm actually looking at 32.
32.
32. 2.
2.
Is this one doesn't sit well with me. So I want to know under which circumstances can we say an official is actually justified or allowed to claim that he actually committed a GBV violence or I mean acting in an official capacity? Because I think from as far as I could remember, even if it were instructions, I mean, unlawful orders, no one is allowed to even maybe accept or follow unlawful orders, even if they are from the employer. But under which circumstances can we say, okay, he was doing this, but in his official capacity, and as much that we say even the government should be liable instead of holding this perpetrator to the letter of the law as a person although maybe he was wearing government uniform or claiming to be doing his work, but like usually the instances like this will usually be happen with police. But I have a confusion with this provision. Can
Yeah,
you
because
clarify?
you are looking at the common law principles of when a person is on a frolic of their own. I think that's what you're referring to, isn't it? In negligence, in the law of tort, when a person is on a frolic of their own, then the person meets their own liability, whether it's a public officer or a civil servant. Like in those days, there used to be, the public office is much broader than the civil servant, but a public officer, right? So you are saying in such instances, the government shouldn't pay. That's what you are actually saying. Or am I not getting you right?
Yes, that's what it's because I feel like we are trying to really move or shift the blame partly away from the perpetrator, because I think victims are not allowed to probably say to make double profit, if I may call it that way. Like if you have suffered an injury and the court feels like you deserve a 1 million compensation, you cannot get a 1 million from government and then 1 million from the perpetrator. But then if the government pays $500,000 and then the perpetrator pays $500,000, it's like the perpetrator is being made to actually get away with making these violations, because now half of it will be paid on his behalf or something. So I'm like, why are we really trying to engage the government instead of saying the perpetrator should always be the one who bears the plan of the full extent of his violations?
Okay, let the other committee members, before I come in to explain, make a comment on these issues. Zimbabwe, Namibia. Namibia have been too quiet. Have you
Perhaps
took
we
too
can
much
have
scones at tea?
We can have your explanation first to guide us. And then
So
we may comment.
the whole essence of this, again, please look at those EISP that I directed you to, the UN legislative guide and so forth, so that you can familiarize yourself. So the essence, yes, we know the frolic rule. The public officer was on a frolic of his own, but that doesn't help the GBV. So we expect that the government in such a case will take disciplinary procedures against that officer and surcharge that officer. But by the time such proceedings are complete, the benefit to the victim is basically lost and may never come. So in this case, we're stating that the government pays and surcharges the perpetrator at a certain rate. Most of your countries, I think there's a percentage in your where you cause loss to the government. In your finance management laws, there's actually a percentage. So I can just put here as prescribed, so that you know that it's actually a surcharge which will come in where the public officer has cost government money, but the government pays and the perpetrator also pays, but at a prescribed rate, right? Because the government itself did not monitor those officers, did not supervise those officers to ensure that they obeyed the rules. Because it's not they're not committing the GBV, but they are violating the GBV violence laws, the GBV laws. That's what's happening. So there's lack of supervision. So there's joint blame. If the government had supervised and ensured enforcement, effective enforcement of the GBV laws, then the officer would have been a disciplined officer. But in this case, there's a lot of impunity in handling GBV cases. Most times, all your laws are never respected. You heard what the Chief Parliamentary Council of Zambia said, that most of the laws are basically not being operationalized. What you need is effective supervision, close supervision, especially for the police. The police act in impunity 75% of the time when they're handling GBV cases. So if you look at the recommendations from all the protagonists of GBV laws and how they should be crafted, they actually say government should take some blame for the acts of public officers who are actually investigating, investigating, and implementing GBV laws. So that's the explanation to two, and it's not new. It's not new and it's not strange.
Okay,
Yes,
okay. I understand vicarious liability, of course, it forces the employer, being the government in this instance, to actually take responsibility.
Yes.
But I'm saying, fine, because now what we want to avoid is to put the victim at the worst case scenario where now the victim might have to wait forever to get the compensation.
Yes.
But as it is couched here, it looks like the victim, after getting compensation from the government, he can also go again to look for compensation from the perpetrator. And I'm saying it might amount to double profit or double gain by the victim from the same incident. Instead, if the government can pay the compensation or restitution to the victim, and then the government will be left to internally get back whatever money it spent on the victim from the perpetrator. It's now a different thing. But as it is, it looks like after getting compensation from the government, the victim will also get another compensation from the perpetrator. So I'm saying it might be a window to open up for, unjust enrichment.
Yeah,
So,
I'm saying what you are saying, but there's another provision where the perpetrator does pay, okay? But in this case, we want to make sure that the government understands that they are paying and the perpetrator is paying, because this is a public officer. So they may of course, a surcharge is not the full amount of the loss. It's always a percentage of the loss. Unless you want us to build in and say restitution from the government, which shall then surcharge the perpetrator, if you want us to put such wording. But otherwise, the idea, yes, it's both, because the government is not meeting the full compensation. The perpetrator is also meeting a percentage of that. Remember, these are public officers. We are not talking about, and unless we change perpetrator to public official, if you want it that way. We put public official here, restitution from the government and the public official. And I think that's what was meant here. It was meant for public official because it's a surcharge. This is how it was meant to be, public official or agent.
I think I'm a bit lost, but okay, let me just
because there is a part where the perpetrator can pay, must pay.
Yeah.
But here we are dealing with public officials who do not uphold the gender-based violence laws. We are not talking about a public official who actually causes the gender-based violence.
Okay. This is more like just an obstruction of justice.
Exactly. Remember, we're talking to access to just exactly. That's why even perpetrator there was not appropriate. We should just have repeated the public official or agent.
Okay.
They're just violating the law. They're with impunity. The impunity we're talking about. Are we now clear? Yes, and so I've changed it to make it much, much clearer. I think perpetrator there was being used in generic terms, that the perpetrator of the violations. but it's actually the public officer themselves. Anything else? Thank you for raising it anyway, Lesotho, because it was definitely going to cause some confusion. Let's go to 33. Financial assistance from government. So even here, we have to be very, very careful which perpetrator we're talking about. So when I'm proofreading this part, I'll be very careful as to whether I'm talking about the perpetrator of gender-based violence or the perpetrator of violation of the laws. So we'll be very, very careful. Mr. Rapporteur, please note that we need to separate the public officials not abiding by the law and the perpetrator of the actual violence, what their roles are or what their responsibilities are. Is that okay? Can we move to 34, procedures and legal services to ensure access to justice? Yeah.
I have a concern in relation to 34.2 that deals with mediation.
Okay.
Because it actually prohibits mediation process from any form or kind of gender-based violence. And I don't know, especially in family setups, whether this will actually be well accepted, because sometimes you find that, especially in this sexual offenses, because some of them, they happen in a very complicated scenario. Like sometimes it can even happen in like between a husband and a wife, and Sexual Offense Act is usually very strict as far as how it interprets sexual offense. So it looks like it doesn't give it, like once something happens and comes up straight, you should be taking a legal or court process, and it says no mediation whatsoever. And sometimes you find that, like looking back home, some of our people are very traditionalists. It actually takes time for them to really understand and appreciate their rights over their spouses or their partners, and what they should and what they should not be doing. So wouldn't this appear to be a bit more harsh to actually like say every other gender-based violence, regardless of what form or kind it is? I mean, I'm a bit concerned about this.
Yes, there's also a number of stakeholders through the consultation process raised the same concern, but we tried to explain it. Please, members of the committee, please, can you discuss this important aspects? Again, it's contained in the UN legislative enactments. So please, can we discuss it and see whether we want to lower the golden standard? The gold standard, not the golden, the gold standard. Please, can we debate this? It's very important. Because it hasn't only been raised by Lesotho, it has been raised by other countries as well. during the consultative process. Zimbabwe, we are discussing, as you stepped out, we are discussing the not allowable mediation during any proceeding relating to gender-based violence. And I've just informed the committee that this has not only been raised by this committee, by Lesotho, but by other stakeholders who we consulted, and an explanation was given. But before that explanation is given, I think it's such an important issue which you as lawyers need to debate.
For me, this one is a very critical one to keep. I don't know if the proposal is to remove. Is it to remove?
I would say yes, because I'm saying it's a bit harsh, because like it cuts across, but if at least it would say certain GBV violations, because like they differ in degree, but because like now it says every other GBV violation, regardless of whether it even happens in a marriage setup or what, I mean, just doesn't cut across. So I feel it's a bit more harsh.
Okay, maybe I kind of see where you're coming from in terms of what you're calling the different degrees of gender-based violence. But for me, the biggest drawback in terms of getting justice for gender-based violence is this mediation. This mediation affects statistics, all the statistics. You get 45 reports, only 4 go to court, only 1 is a conviction because of this mediation. Because there are so many factors involved. More so if it's a domestic setup. That's when those cultural practices start to kick in and mess up everything. For me, I would rather have it there. But of course, we all still have that leeway to perhaps adapt it and adopt it in a way we prefer. But for me, I would like it if everyone adopted it. But now I'm just imposing, but that's right.
But that's the argument which the protagonists have been put forward. That's why the UN guidelines actually removes mediation completely, based on your argument, Zimbabwe. Can we hear from the other countries? This is very important. I think we need to discuss this. Mauritius?
Yes, I think that there should be no mediation for these kinds of things, because I think in mediation, you're trying to reach a settlement, but in these kinds of cases, there can be no settlement.
Can you remove your thing? We need you. I think you're saying
yes,
something
I'm
important.
just saying that in these kinds of cases, you cannot have any settlement because one, it distorts the figures as rightly pointed out. But secondly, there's a give and take in any mediation. There's a settlement that's reached and a middle figure. But here in those kinds of cases, you cannot have such mediations. So I would not be for removal of that provision.
You're against removing it?
Yeah, against removing.
Okay. Again, very good argument made there. Anyone else, please? We need to hear all the voices. Against, yes, Seychelles?
Yes, I also would support not removing it, and also to point out, maybe I see where you're coming from, but the moment it's an offense, and if it's criminal, there cannot be mediation. So if the offense is not criminal, then it must be some sort, like you are saying, it could be civil. Then marriage setup and all that, then there would be mediation. But once it escalates,
the prohibition, yeah,
there is no mediation.
Yeah. You see, all those arguments were put that this is actually a criminal offense. And further, even if you take it, you want to lower the standards. The GBV, one of the main concerns in GBV is that male dominance, the manipulation by the family of the whole GBV case against most likely a woman and the children. They are the worst victims of manipulation by the family. And it's been going on for so long. So most of the guidelines on GBV and the legislative provisions actually provide for no mediation. It's a criminal offense and it must be treated like a criminal offense. Let it go through the criminal justice system or the administrative justice system. If it's sexual harassment, when you go to the laws on sexual harassment, it's the first instance, it's done through human resources. The victim is not satisfied as to those processes. They go to court and file a criminal prosecution. A criminal prosecution will take place. So inevitably, it's a crime and no other. So mediation has been standardized in such instances as being no deal. There's no deal for mediation in GBV. So this we explained, and I think most countries understood the reason why mediation cannot take place in GBV cases. Lesotho, have we convinced you?
Oh, yes, you have. I mean, I understand why the reasoning behind it.
Thank you
But
so
the
much.
practicality of it is something else, but I understand why.
I know they
the gold
always
standard
do
has to-
try, the family comes in,
Yeah.
but you know, the more the family comes in, the more the perpetrator becomes so devious. You find the GBV never ends. It's just perpetuated. The more mediation, the more GBV. The more mediation, the more GBV, because they know, we'll call our families, especially as Africans. We'll call our families, they'll settle it. They'll settle it. But the woman is aching inside. Mentally, she's being destroyed. This manipulation needs to stop, especially for women and children. They manipulate the whole case to the favor of the male dominant partner. Okay, so thank you for that. Can we move on? We are nearing lunchtime. We've got 10 minutes. 35 rights of victims during judicial or quasi-judicial proceedings. Okay, let's move on. It's a quite long one, so let me just pause a little bit. Let's go to 30 and evidentiary procedures. Okay, we come to the end of part, what was that now? 4, part 3, part 3. Let's start part 3 since we are knocking off 7 minutes to the hour. Let's start part 3 exactly at 2 o'clock, so that within 3 hours, I think we can actually finish. Because we have basically about 50 pages or so remaining. I think we are making good progress. So let us come sharp 2, so we continue. Thank you so much. I think we had a very lively debate this morning. We managed to interrogate quite a number of issues and put right some of the issues that weren't just right. Thank you very much.
Thank you, Mrs. Jala, and thank you, colleagues. Thank you for your participation. Lunch will be served in the restaurant again like yesterday. And as she indicated, we meet back here at 2. We have some masks, I think. If there's anybody who needs masks, yesterday some people needed masks. I think they're available for us there. If anyone needs some extra masks, thank you. And I hope that everyone has their results for the COVID. If there's any problem, you haven't got them yet? Oh, okay. All right. I think so far everyone is fine. Yeah, should be okay. Thank you.
Am I the only one? Are you in a break?
SG, we are taking a break for lunch.
I thought so. I kept increasing my volume. I thought I heard that. Okay. Thanks.
Okay. We'll be back at 2 sharp.
But why are you not eating?
We are watching our figures.
We are so tired. We just sat.
No, I've been feeling sorry. I've been feeling sorry for you because, yeah, but it's fair. I like it.
Yeah, it's going very well. We have very good participation.
Yeah, no, certainly.
The engagement is wonderful.
Yeah, no, I've been following, so it's quite good. It's quite good. Okay. Anyway, Madam Claire, sorry, no, I forgot that you're on air. I'll call you. Thank you.
Okay, no problem. Thanks. Good afternoon, colleagues, and welcome back. We'll proceed as agreed with the rest of the deliberations. Mrs. Jala will lead the discussions. Thank you.
Thank you very, very much. Welcome back. I hope you had a sumptuous lunch and we won't feel too sleepy now after lunch. So we can proceed now to part 4 on prohibitions of all forms of gender-based violence and attendant procedures. Again here, I think a reminder that in drafting national legislation, a member state draftsperson should take into account the justice system and penal sentencing policy, criminal laws impacting on the matters provided for in this part, and do effective cross-referencing. I think this is very important to do cross-referencing, for example, to existing laws on criminal responsibility, marriage, health research, health, other gender-based violence, trafficking, etc. And if need be, make consequential amendments to such legislation in order to meet the objectives of this GBV model law and harmonize the law to ensure efficacy of the law. Note that where a member state already has these provisions in its laws, then the need to add from the commencement of the law is unnecessary, and if necessary, replace with appropriate language such as this act, law, enactment, etc. This comment applies throughout the model law. So, you know, we are dealing with criminal liability now. So we must be very, very careful that we are not providing for retrospectivity in our national laws. So that's why I'm just trying to alert you that it's from the commencement of when you are amending, so that we don't go foul of the criminal justice system. So now let's look at Division 1, which is the general requirements for criminal justice system. And we start with Section 37, dealing with prohibitions relating to gender-based violence. Can I have your comments and any changes you're required to make under Section 37? Zimbabwe? Oh, from who's on the floor? Mozambique? Who's on the floor? Pardon?
Your screen.
Yes.
The screen.
Oh, it's our colleague. It's our colleagues here, the technical people. Sorry. Let them just come and do it. Okay, thank you. Oh, it was removed. I didn't even notice, you know, that they had removed the cable. Yeah. Sorry, the technicians are just looking for the cable. I think it was removed during lunch. So just give us 5 minutes or so. I think he's run it this side. Here, just check this side. I think that's where you run it from.
Where's the HDMI cable? Share. Where's the sharing cable? Is it?
Oh, you've got managed? Oh, no cable. Okay, can we proceed now? Yes, Zimbabwe, who was on the floor? Oh, we are missing an interpreter?
Hello, we can hear you. Yes, we can hear you. Okay, he's saying you need to mute the other interpreter. It's done, I think. It's not. The other interpreter is still on. Okay. You muted him? You are not able to mute. Oh, it's the host. Can you ask Ronald to mute him? Solunga.
Who do I have to mute? This is Wilfred speaking.
Oh, Wilfred Solunga, the Portuguese English interpreter.
Okay, I'll do that now.
Thank you. All right.
I think we should be good to go.
Okay. Are we good to go now? Okay, section 37, prohibitions relating to gender-based violence. Yes, Seychelles, please go ahead.
Thank you. When I look at the head note, it says prohibitions. But when you look at the text, the provisions, it's about sentencing policies. So maybe it's more appropriate to change the head note to reflect the provision below. Thank you.
Can the committee please comment on that? Section 37 is saying that the heading prohibitions relating to gender-based violence, because we are looking at general requirements for the criminal justice system. The first one is prohibitions. It says these are not prohibitions, but the section relates more to sentencing policy. Can we look at them and see whether we agree or not?
I agree, actually.
Who's speaking?
Zimbabwe. Zimbabwe.
What are you agreeing to? Please, let us be, so of course the other committee members are also thinking about it. So if you've got a comment, please say it in full. Yeah.
I was saying I agree that these are not prohibitions relating to gender-based violence. I think the section that actually has prohibitions is that one that's titled protections from the one under rights. It's more, it addresses more the prohibitions against gender-based violence than this one. Because this one, instead of telling us what can't be done, it's telling us what we should do.
Yes, anyone else? Are we all in agreement that we change the heading to sentencing policy relating to gender-based violence?
Perhaps not just sentencing, but penalties relating.
Pardon?
Penalties.
Penalties.
Yes.
But we're talking about developing sentencing policies. Read the chapeau.
Yes, but the other subsections.
Okay, the first one, sentencing policies.
Yes.
And penalties to eliminate, to do this.
Yes.
A person shall not be tried by,
Yes.
shall be tried by a competent, any sentence imposed on a paper is still sentencing. Despite any other law to the contrary, a judiciary shall not provide a reduced penalty, still sentencing. Where perpetrators repeated shall impose still sentencing.
Okay.
A judicial institution shall not impose any fine, still sentencing. Where compensation is an element in penalizing, it shall not be substitute, still it's still
Okay.
shall responsible shall regulate marriage broking and shall put in place measures to minimize risk. Now, eight has to be on its own, and the only ones I can see is 2 and 8. 2 and 8 can be removed into another section, but the rest is sentencing policy. Are we agreed? Are you okay, Seychelles? Okay, then we'll, Mr. Jared, subclause 2 and 8, we shall put into a separate section. We've got that. Okay. So let us, are we okay now with 37? You satisfied, Seychelles? 38, measures to protect and promote the rights of victims. Let us proceed to 39. Intervention programs for perpetrators and alternative sentencing. Let us go to Division 2 now. Offenses related to gender-based violence. Prohibition of gender-based violence 40. Yes.
Okay, thank you. With regards to section 12,
Which section?
we are
40?
we are 40, but
40.
but it's with regards to section 12. When I look at 40 and with regards to section 12, I see that either it's a repetition
Section
or
12.
yes.
Let me just get to it without going. It's under the restatements.
It's a protection from gender this one.
Yeah, now this is a restatement.
Yes.
Please
but there
don't
is-
mix them.
But there is an offense there created.
Yeah,
Yeah. And when it's a restatement, it's a general statement.
yeah, yeah,
Speaking, saying,
yeah.
So why is there an offense? So if we move the offense, if we leave the offense at 40, and it says all forms in 40, all forms. So we let that be a general statement. No need to provide the offense. It is covered under 40 as all forms of, because
Oh, I'm looking at the wrong one, sorry.
you are creating an offense.
That's, you said 12, eh?
Yeah.
Okay. Okay. Okay, have you got his point? He's saying we shouldn't put the offense under protection from gender-based violence, since we are stating under 40 that all forms of gender-based is prohibited. So we should remove 5 and migrate it to 40. Are we all in agreement? Is that okay? Makes sense? $12.5. Migrate 12.5 to 43.
So if we're saying 12 must only maintain the provisions.
Yeah, we must
from
only
the
leave
right-
the
Okay.
restatements.
Okay.
That's what
Then
he
we
suggests.
take out, so it also, so does it include 4 as well?
Does that include what?
4 as well, 4 and 5. 4 says marriage, cohabitation, or a romantic or intimate relationship shall not constitute a defense to a charge of marital rape or any
That's
other.
fine. That's
This
a
one
policy
says here-
direction. What we are migrating is only the penalty clause. That's what we are migrating. So what we are going to do for assurance is that in the restatements, if an offense has been created in relation to the restatement elsewhere, we will migrate those to where we have actually provided the offense. So we look at that throughout. But if we have not created an independent offense relating to a restatement of the right, then we will leave it there. But if we have created, like in this particular instance, we have created an offense. So it's appropriate that we migrate 12.5 to 43. Okay. Let us look at 40, thanks, Seychelles. Let us look at 41, collusion in gender-based violence offense. Okay, let us go to 42. Other gender-based violence-related offenses. Okay, let us now move to Division 3, processes and procedures. 43 factors when imposing imprisonment.
Comment?
Yes, Seychelles.
Yes, thank you for 43.
Pardon?
43.
43 what?
Yes. Should 43 then also migrate on the section where we discuss policy, sentencing policies?
These are now factors when imposing imprisonment, just imprisonment when you're imposing imprisonment. So we want them to come out very clearly. What are these factors? We're not talking about the sentencing policy, but the factors that they must take into account, the judges. So I think it's better separated.
Okay.
Yeah. (44) No criminal or administrative liability when subjected to gender-based violence. (45) Matters of facts. Yes, Namibia.
Matters of fact, 45, is it sub 1? If you
Yes.
look at 36 sub 1, evidence
36.
sub 1, it appears to be the same thing.
36. Okay, 36. Evidence and evidentiary procedures. So which one?
So the first one, for the purposes of a law on gender-based violence, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of the judicial institution, the quasi-judicial body. Let me read 45 again. Go back to 45.
Okay, maybe we can remove that particular one.
Yeah.
On the first one. Or shall we remove it on 36?
I think
we can, it's best remove the 36 one, which are dealing with evidentiary procedures.
Yes.
So we retain the 45, but we remove the 36. Let me just highlight it. Have you got it, Mr. Rapporteur? No, what we are doing is we are 36, let me just get to it. It's like a repetition, but in the wrong place. 36 deals with evidence and evidentiary procedures, but here we are talking about matters of fact, which we have dealt with in 40. So we want to delete this one. We are deleting this one. Okay, the one in 36. So we are deleting The 161, we will number later, don't worry about that. And then we are retaining it under 40. 45, sorry, 45. Are we good? Okay. Let me just get the correct one. Was it 45? Yeah, let's see. I think it was 46, 45. So we're retaining the one in 45.
And the same thing is, oh, sorry, was somebody speaking? Okay, the same thing is present under 45 sub 2. No, hang on, is it 45?
No, 45
sub 3, 45 3 and
Yeah.
36 3.
Evidence of a husband ownership. So we'll delete it. If it's repeated, exactly. So we'll delete it in
Under
36.
yeah.
36 3 will be deleted.
And we can retain 45 3.
I think what must have happened, drafting a model is what must have happened is that after I'd already put them in, and then the experts came in and felt it wasn't there, and then we just repeated them again. That's what must have happened. So 36 3. Yeah, that's, have you got it? You've got it? Yes, yeah. Because these are evidentiary, so they go to the evidentiary one. And then we keep all the matters of fact. Now let's see, this is evidentiary, and you can see it's relating to the facts. So these should just remain under the one dealing with facts.
Ms. Jala, is it necessary to have those issues relating to matter of fact as part of that provision, or rather to delete the entire provision that relates to matter of fact and contain them in the evidence? Because I would consider these to
not 4, must be 5.
Or 5, yeah. No, I think let's separate the facts one
to the evidence.
Yeah, let's leave the facts the way they are, and then leave the evidentiary rules the way they are. Yeah, it's just that unfortunately there was some repetition because it was being done at 2 different times. That's what happened here. So, but it's preferable just to leave so that the judges can actually see clearly which are matters of fact and which are matters of evidentiary rules. Anyway, we'll go scan through them again very carefully and make sure that they are not repeated in 2 different places. So thank you for that. It was a good one. Shows you have read the whole document. Have we got it? So we'll separate all there. So you have to read it very carefully when you are doing your report. Yeah. Let's go to 38, measures to protect and promote the rights of victims. Oh, we are in 42, sorry. We are in 42 now. 42, we've gone through this one, factors, we've gone through that. 45, 46. Protection of witnesses, victims and witnesses. This was the most discussed with our technical working group, because you can imagine, because most laws, there's so much lacunas with respect to this part. So the technical working group actually made a lot of input into this part. Okay. 47, child victims and witnesses. Okay. We are satisfied. Let's move now to part 5, early and effective response mechanisms and referral systems. Division 1, general response and referral mechanisms. I don't know whether we should change systems in the main heading to mechanisms or the other way around. Maybe general response and referral systems. What do you think? Mechanisms. Eh? So we put mechanisms in the main title as well. Okay. Let us look at 48, simplified procedures.
Sorry to take you back.
Oh, okay.
Yeah, I
okay.
had not switched on my mic, sorry. I was saying the referral part, that's a system. And then it's those responses perhaps that are mechanisms. So you were right in your first, yes, to change it to system.
You want it back to systems?
Yes, I was saying in hindsight, it's a referral system, that process. But maybe the other responses are the ones that are mechanisms as stated in the heading. And you were correct in your first.
And then this one, you want to leave it at mechanisms? Systems?
System, yes.
Okay. Okay. 48.
Sorry, I want to make a contribution.
Yes, yes.
Perhaps it's somewhere else in the document, I'm not sure. But under this referral system, I was also thinking of a scenario whereby, you know,
Which section?
49.
49.
But I'm not sure if it's.
Or you've moved to 13. Okay, let's move to 49. Because that was long. I was giving them a little bit more chance. So let us move to 49, response to gender-based violence complaints by law enforcement officers. Yes, Zimbabwe.
Okay, So I'm not sure whether it falls under 49 or 48 or if it's there. But I was thinking of that scenario whereby do we have provision where a person can make a report, an official can make a report that they suspect that it's a gender-based violence case, even though the victim has not reported it as a gender-based violence case, but perhaps it's a totally different scenario, like maybe a medical expert, a medical practitioner, or maybe it's a prosecutor and they're prosecuting this person for robbery or something like that. And then they have a feeling that with the way the case is progressing, there might be a case of gender-based violence that is behind the case that they are prosecuting, and make a referral that it be a case of gender-based violence as well. I'm not sure if we already have that provision. I didn't see it
In
before.
the same one, I think there's both.
Okay.
There's where there's a complaint and where there's a report. So there's two,
Okay.
a complaint direct and a report.
In 49 or 48?
Relating to, in 48, relating to gender-based violence, such as reporting, receiving a seminar. Okay, let me just find it for you.
Okay.
Yeah, here in C, for referring and lodging a gender-based violence complaint or report to an appropriate authority. Because a report can be made by a neighbor, an intervener, a human rights organization, or anything. So they make a report and the victim makes a complaint.
What
Yeah.
about even with other officials?
Anyone can make a report.
Okay.
Yeah,
So even
anyone
the
can make a
prosecutor.
report. Any intervener can make a
Okay.
report. And the complainant, the victim makes a complaint.
Okay, so
Yeah.
it's covered.
Okay, we're on 49. You see, it's even emphasized, if you can see, Zimbabwe in 1, all law enforcement officers shall respond promptly to every request for assistance and protection in case of gender-based violence, even when the person who reports such violence is not the victim. So it can be anybody can report a gender-based violence offense. Yeah. Okay, let's read 49. Yes, Seychelles?
At 49.4.
49.4.
Yes, it says a law enforcement
Yeah.
officer shall ensure that gender-based violence are prosecuted. Should we also add a prosecuting authority? Because usually it's the prosecuting authority that a law enforcement officer investigate, the police they investigate, but it is the prosecuting
authority.
Who
Depends
has
on
to-
how we have defined law enforcement officer. It may include a prosecuting authority. But we'll check anyway. We'll check, rapporteur, make sure we check that the definition does include. I'll just stroke it. Okay. I've just highlighted it. It's got the question, it's got it. Yeah, I remember putting something, but I wasn't too sure. So, response to gender-based violence complaints by prosecutors. Okay, let's go. Let's move to 50. Yes, Shell's come in.
Yes, thank you. At the 55, it says where the
That's
AG,
55
yes, 55,
or 55, okay.
where the AG is consents. Shouldn't it be decides? Because in most situations, the AG has the sole discretion to continue, discontinue,
Yes.
prosecute. It's his sole discretion.
Or you want to use decides instead of consent?
Consent, it's like he's
Yeah?
discussing with someone else, trying to, you know.
The committee members, Seychelles wants to substitute consents with decides.
It's like someone else is telling him.
Members of the committee? Substitution? Yes?
Yes, I think we can delete consent too and just have where the Attorney General discontinues
Okay,
a case of gender-based violence.
okay. Committee members, there's another suggestion on the floor that we just go straight to the action where the Attorney General discontinues a case of gender-based violence. Is that fine? Committee members, is that fine? Thank you. Okay.
Sorry to
Zimbabwe.
take you back. I was still thinking. But here the heading is about the work of the prosecutors under the AG, right? So is it not that we're acknowledging that they would need approval of the Attorney General to discontinue a case?
Pardon?
Under this section,
Uh-huh.
I'm saying we are saying response to complaints by prosecutors.
Yes.
That's the heading that we're dealing with.
Yeah, it is. It's because you are still talking about the prosecutor here. So it
Yes.
still falls within the same range.
Yes.
Yeah. So in other countries, by the way, it's the DPP.
In my
In other
country,
countries, the Attorney General. So I just put stroke DPP there.
yeah, it's fine. Mine is the NPA,
Some
but
countries, it's
not,
the Attorney General.
for mine is the Prosecutor General.
Yeah. So
Yes,
I'll just put a note there to make you aware that it depends on who does this constitutional function. Okay?
But
no, for this one, we haven't included them in any of those. So I would rather just put a footnote, because normally it's either the Attorney General or the DPP in most of your legislation. We've looked at them. I think, which countries can I remember? Anyway, there's some countries which is the Attorney General.
yeah, but my point was more often than not, there has to be consent from the AG.
The consent.
Yes, because the proposer is the prosecutor, right, to discontinue. And then once the AG or the PG approves that request to discontinue, then the prosecutor can do the action underneath.
Yeah.
Or are we suggesting
Yeah,
that?
because these are the duties. The emphasis is what the prosecutor should
does.
do.
Yes.
What is the effective response? So once there's a discontinuance, the prosecutor must inform.
Yes.
That's why it falls under 50, the response.
Yes,
This is response to gender, yeah.
I agree. I'm just saying that because this is the work of the prosecutor, I still feel it's important to include consent. Because
Or
for
the Attorney
this
General
action
must
to
be
be
consent.
carried out, the prosecutor first needs the consent of the AG or the PG to
Yeah.
discontinue a case, because
Yes.
only the AG can either refuse to prosecute or accept to
Yes.
discontinue.
Yes.
So it's difficult for us to place it as if it's to the sole discretion of the prosecutor to do that. So I still feel keeping consent.
Okay, can we have comments on that? Zimbabwe is saying it's appropriate here to use the term consent as original use, then to go straight to the decision of the Attorney General or DPP.
Yes, otherwise we would have to say where the prosecutor discontinues the case and not involve the AG in this. Because the minute we involve the AG, it's because we're acknowledging that consent.
Okay, so we go back to consent. Okay. Okay, have you got it? Yeah, going back to original. Okay. Let us look at 51. Response to gender-based violence complaints by health providers. Lesotho, yes. No. I'm seeing double. Yeah.
Sorry. We were discussing something of record. I think that 50 sub 6.
Which one?
50 sub 6.
6, okay.
The last one. I think the use of the word severe there.
Severe, severe, not those light punishments, but severe. Because this is the core, this is where we found the most impunity as well.
I think Lesotho
where
doesn't
they
like to see people
disregard a
suffering.
lot of issues. You know, because most of these prosecutors, let's admit, they are police officers. They are actually police officers. The way they carry out their work is just something else. And the beauty about it, when we were having consultations with the police, they admitted to all this. They actually admitted, and they said it's good that it has come out like this because there's a lot of impunity in the police force. We were waiting for them to be very unhappy with these provisions, but they were very happy with them. Yeah. 51, response to gender-based violence complaints by health providers. We have done most of it, isn't it? And then here you want the same thing as we said, we'll put imprisonment in all of them. Got it, Mr. Jerry? Yeah, remember we had said we'll do consequentials. Yeah. 52, developing innovative and proactive models to respond to gender-based violence. Yes, Sessions.
Thank you. 52.1. Instead of developing new, why not we say developing effective? Because if you are developing, it will be something new, but will it be, is it effective?
Okay. Have we heard Seychelles comment? Change new to effective, or would we have to now say more effective? Because they'll be there already. And I think of the wording, you know, we're always looking for that optimal word which we want to communicate. So if we say effective, meaning they're already there, and we just want to enhance. When we say new, they are not there, they are innovative. They are completely different from what's already there. So what does the committee, or what do you think as committee members? Is it effective or is it new? Would you, maybe, would you want to put in new things which are not effective?
We are looking forward to the fact that when it's new, it's better than
exactly
than what we had.
Exactly.
So it would be essentially effective. Yeah, it's not always the case.
You know, I just love this like working with the drafters like this, because I'm now in the private sector. I draft in the private sector. So there's no like internal legislation committee. But when I was in the public sector, we always had to have an internal legislation committee where all the drafters come together and look at a draft. We used to have such fun. Because the things that we make, mistakes that we make as drafters, doesn't matter how senior, they are there. And then even our thinking sometimes gets warped. We used to have good laughs. The internal legislation committee is the best. You learn a lot, and you see your mistakes flying in your face. Yeah. Yeah. So, Charles, are you happy? We leave it at you. Okay. Division 2, complaints, grievance, and appeals process at places of work, educational institutions, and communities. So we have 53, adoption or adaptation of grievances, complaints, and appeals processes. '54, 4 principles underlying grievances, complaints, and appeals. Okay, I see none, no hand coming up. 55, mandatory requirements for grievances, complaints, and appeals policy. You know, actually, my research on this, sexual harassment at places of work, this particular research has really helped me in legislation that I was doing after and statutory instruments on internal dispute resolution and complaints procedures. It was so easy because I just copied and pasted them into the essay, because the work already had been done by me on this side. And, since these were international standards from the UN and all these bodies, it was so well received. But it made my work so easy, on those administrative dispute settlement procedures. So I'm looking at them and I'm laughing. I said, oh, I did put this in. I put this in. I put this in. So you see, this can help you actually when you're doing so many other pieces of legislation, under the labor code, employment codes, and all these other things. '56, conflict of interest. Good. Let us go to part 6, prevention, protection, support and intervention measures for victims. It's a pity Mauritius is not here. Where is she? Where? No, she's not seated there. Yeah, because I wanted to explain to her that, because this part, she actually labeled it as administrative. But if you look at it closely, it actually amplifies the provisions of the restatement, so that these are also taken to be substantive or operational into subsidiary legislation and not merely administrative. Because if they're administrative, they won't be able to have a statutory duty or statutory obligations to really carry them out. They'll be basically ignored. So let's not look at them just because they are measures or interventions as purely administrative. No, they are not purely administrative. Somehow or the other, you need to draft them in a certain manner that they will actually be substantive or subsidiary legislation. That's when they'll be very effective. And this is what is missing in most of our laws. There's a lacuna after we provide the provision, then we say, so what? What happens after this? There's nothing mandatory anymore after that. So it doesn't work. So let us look at this more on the preventative and protective provisions that must find their way in any GBV legislation. Okay, so let us look at 57, preventative measures and interventions.
I had a question
Yeah.
with regards to that provision. I understand that these are minimum standards or minimum measures, minimum standards.
Yeah.
But is there any reason why we refer to, at least under G sub 2, one shelter or refuge place for providing safe, and then similarly under...
At least minimum, the minimum standard, because some countries, they don't even have even one. So we're saying the minimum is one, minimum standard.
Wouldn't we want to say then just...
Yeah, you can have many.
Many after that.
Yeah, you can have many, up to how many ones.
But
some countries, they can't afford them.
Because this is a goalpost model law, shouldn't we rather say that?
That's the gold standard. At least have one. Not zero.
It doesn't say in every province, in the country.
No, I'm saying let's make the gold standard one in every province.
But what if you don't have provinces like why don't we just say to establish shelters or refuge places for providing safe emergencies? So it doesn't, so you place no limit on it.
But this is just a minimum, there's still no limit.
Yeah, there's no limit, but at least, yes.
People will interpret it.
Yeah.
But they are
because that's what people will interpret it as in saying that, okay, I have one, so I've met the requirement.
To tell you the truth, this is the minimum UN standard.
One in the whole country.
Minimum. Because you know what they don't want? They don't want is not to have at all. You understand? Because most countries, they don't have at all.
Yeah, we understand.
And it's also, you must know the resources.
Yeah.
The resources.
But does it take anything away from saying to develop shelters or places of refuge or refuge places for providing safe emergency, as opposed to saying one shelter? I've
got an idea. I've got an idea because I have seen their jurisdictions where they will interpret the minimum as the accepted standard. Instead of having more, we are having situations where there's violence in rural areas, there's violence everywhere. We want a shelter, we want support in all those places. Perhaps we can accommodate a strategy whereby, yes, it's an expectation that government is responsible for this, but government itself can have a strategy to use the private sector, NGOs who want to play a role and be registered with the government as accepted places of shelter. Because they are doing that with a lot of other areas, like trafficking in persons shelters. Governments are not really building new structures or anything. They rope in the private sector to be registered. So we can actually be able to put a higher number as a minimum and still leave that room for governments to strategize by roping in the private sector. NGOs can have shelters, and those shelters need to be approved by the government to be able to qualify to be shelters for supporting people with people who have suffered, gender-based violence. Therefore, those approved shelters, if they're registered with government, they can operate freely and just meet the requirements to shelter, clean water, security, and all those other things.
Just in addition.
Now here, this is not really, it's not excluding civil society.
Okay.
This is mandatory on government to provide. In fact, let me give you examples. In Zambia, I think we've only got 2. Bwalia, Chief, is she still there?
She's not there.
Yes,
Chief. Yeah. In
Yes.
Zambia, how many shelters do we have by government shelters? Because I know we've got a lot of civil society shelters, but government shelters, how many do we have?
As you've indicated, we only have 2 government-operated shelters. The rest are run by NGOs.
Exactly. So, and that is the whole country, isn't it? The 2 is the whole country.
Yes.
Okay.
Yeah.
In
So you
Zim,
see,
in Zim there are 2
Yes,
strategies.
it is.
yeah, you see.
In Zim there are 2 strategies. Maybe I'm not expressing myself clearly
Yeah.
enough. The government shelters, these ones that I'm saying will be registered with government, they are viewed as government shelters. And then there are private sector NGO shelters that are not registered with government, that operate freely as NGO shelters as well.
Yeah.
So under government, you could have a figure of like 10, but they're just being supervised by government. And then you also have the civil society sector shelters that are running concurrently with the government initiative.
So we don't need, for this model law, we are not concerned with the civil society shelters. Those are free to have even 100, because we can't force them under our model to put up shelters. That's money. But what we are trying here, we are targeting now the government, isn't it? We are targeting the government, not civil society. Are we clear? The model law is targeting member states and not
Yes.
civil society.
Yes, I still felt.
Yeah. So here we are trying to avoid forcing civil society to basically build infrastructure for GBV. They know their duties, they know their line, their geographical lines, their mandate lines. They work very closely with their donors, and we hardly interfere with them, except that they have to register, like for Zambia, under the NGO Act. And whatever they're doing is actually monitored under that law. So for the model law, we are not going to concern ourselves with shelters put up by the civil society organization. So here, the minimum standard for government, what is the minimum standard that you would require? Because we know definitely that we do not want to impose big financial outlays on government. Like if you take countries like, I think it was DRC who was saying they didn't have, I think it's DRC, yeah? With shelters. I think it was DRC, you see, because of lack of resources and things. But we said for the golden standard, at least meet the minimum standard, which is 1, right? So if you feel we need to up the minimum standard to 2 or 3, then make that suggestion.
In your research, I've got a follow-up question. In your research, what's the standard size of an institution, a shelter? How big is that?
The shelter?
Yes.
Oh, it depends. There's various. It depends on what services they are offering there. So you find others, it's only related to basic shelter, sleeping, bedding. Others which provide medical, children care, and victim care are much larger. Others provide, who provide in addition to those counseling services for some children who are now addicted to drugs. They actually have the rehabilitation services. So it depends on how much, to the extent of the services which are being provided. Others are small, others are medium, others are large. So it depends on what government feels they can afford at any one point, or they just refer cases from the sleeping shelter now to other institutions like drug enforcement, like hospitals, the general hospitals and so forth.
I feel like there's a bit of irony here that we are so aggressive throughout the document. We are literally violent. And then we have one shelter, like in a population of 30
I mean,
million,
it's up to you. If you think your governments can
52% is
afford a
female.
higher minimum, we can put 3-4 shelters.
It's
There's
not
no
that I'm
problem.
saying the government can afford, because a lot of the things in here, I can't even say the government can afford. But we're dealing with the standard, the gold standard, like you said. So I was thinking, how then do we end at one shelter? I don't know.
I think
Anyway, it's really up to you, but this is, as I said, the
I
international.
can't fight a minimum standard. It's to my benefit.
What would you think that, like, for example, Zimbabwe would actually
in Zimbabwe, we have strived to devolve to, I don't know how to, the word devolution, I don't know how to unpack that word.
Devolution
to devolve, yeah. So we are really striving to put each organ, each institute, each department in each province.
Striving.
Yes, we are striving. Yes. And when we strive, we don't end at one. Because if the target is 10, we will be resting after every 3. But if the target is 1, I'm telling you, this is easy to achieve. But I don't know if it's effective, like what Seychelles says. I don't know if it's enough. Because one shelter, okay, it's fine.
No, tell me what you think most governments in the SADC regions can afford as a minimum standard. What would you assess?
What about 2, north and south, at least?
Yeah, Namibia?
I think
you are rich guys. These guys, we are poor. These guys,
we can try.
Namibia, Botswana, we follow them. We'll stumble. Yeah, no, and they've got money. These people.
Listen, I think my point was not to set a not necessarily a minimum, but the standard should be left blank. Like if you look at Roman numeral 6. It refers to rape crisis centers, not one rape crisis center.
And you know why?
That last one, rape crisis
You know
center.
why? Because the rape crisis centers, if you look, they are next to hospitals. So most rape crisis centers are within a hospital or a clinic. So those are many. But the shelters, those are the problem.
But we really, so then why don't we keep it blanket and say to establish shelter or shelters, plural, instead of one shelter? And then it's up to the government, because then by interpretation, the minimum would still be 1. Shelters. But they're shelters. If there are 2, they are still shelters.
It don't work.
If there are 2, they are still shelters.
That's why the UN, that's why we must put a number.
But if there are
just
2,
to force government to reach at least that number, we need to put a number.
Yeah, we'll just say that the requirement is 2. We have made 2. That's enough.
Okay, let's put
north and south.
So 2.
3. If it's going to be housing, all those 25
million people in Namibia, please. We can't have 2. We only need 1.
For you, 1 is enough. But your population.
Namibia, and they've got small population. No, yes. And the expanse of the country. When you talking about 10 provinces, you're talking about 72 districts. We are just creating a very high standard, very high, you know. Yeah. So This is just to force the government, at least, please. Some countries, they've got zero. Eh? Yeah, a gold
Zimbabwe
standard,
surpassed
which
the
is
gold
one.
standard. I think
Because
Zimbabwe
others have got
surpassed
zero
the
and they
gold
don't
standard.
even, you know, you can't just be relying on civil society for everything. You as a government, you are fighting GBV and you don't even have one shelter. One. Eh?
We have, Zimbabwe has,
You know.
many. I think we've got 5 even.
You in Zimbabwe, you are progressive
We have
5.
many.
You had
Yeah, because we've
the chief.
also converted social service accommodation that we had under the Ministry of Labor and Social Services. They've got a lot of infrastructure that has been converted into all these requirements. So it's not really, and then we've got civil society that has been very active over the years. It's one, it's not
we
one.
Civil society, they've got many.
Mm.
But we want to show commitment from government. Let the government at least show that they are concerned.
Yeah, they are.
Yeah, Zimbabwe is very progressive on these issues of child marriage, GBV. I like how they are actually progressing in that line. You know, Zimbabwe is doing very well. Even their courts, the way they look at the principles and concepts, they're actually using the functional approach to interpretation of legislation, where they are moving away from this standard interpretation, golden mischief rule. No, they are looking beyond. And they're doing so well that you see their jurisprudence in these areas is actually growing. And we are all looking now, even if you look at my position paper, most of the cases that I actually came up with is the Zimbabwean cases. Because their jurisprudence is actually growing very fast. The judges are very active because they're looking at the functional approach to interpretation of legislation, whereas most of our countries are stuck with the golden rule and the mischief rule, the literal rule, in other words, which doesn't help in such cases. It doesn't help. Okay. So I've changed to 2222. At least we'll force them, at least. Pardon? Oh, yeah. You know, it always happens that, you know, we'll take care of that. We'll take care of that. When we come to, yeah. I don't know why it does that. It irritates. You know, because you know what it does? It picks up from the last one and then it comes, yeah. It always does that. Now you'll see what will happen. My whole document will go haywire. Yeah, better. I'll just use it when I put in my mirror. No, I mean my ruler. Okay. Yeah. Messed up my document. I have to come and and I hate formatting. It just take up so much of your time. Anyway, at least it will remind me. Okay, let's go to 58, basic benefits and services. You know what's the time? 15:15. Basic benefits and services to victims. Yeah, we'll have our tea at 15:30. And you can see for the protections and preventions, it's at least the basic minimum that must be met. Because even when you look at the international instruments, it says provide for minimum measures relating to legislative measures. If you read them, that's how the obligation spans out. Yeah. Namibia.
Yes, comment or question. That's sub 6. You go
Where?
to sub 6, 58 sub 6.
58.6, yeah.
we here refer to the government shall establish public safety homes, plural, shelters, plural, public foster homes, safety homes, foster homes. So it's not just one.
Yeah, because we provide for
Mhm.
the minimum and then just open it up. We have the general provision. So in fact, your concern was actually already taken care of. But the minimum standard was that 111. And then this was the general, just general requirement. Okay, so this is just the general, but minimum. That's what we were more concerned with. But they can provide as many as they want. Hmm? Any more on that? "58 protection orders. Have you seen your concern is still, and you'll notice that certain issues are repeated in another part if it's relevant to that part. So your concern still on the interveners, you can see it's still reflected again in 1B. Yeah, it's emphasized in 1B.
So despite that same provision, despite any other law, on receipt of information from a person who has personal knowledge or information relating to an act of gender-based violence having been committed, a judicial institution shall issue a protection order.
Yeah. Yeah. On receipt of information.
Without any application,
on receipt of information. Remember, we dealt with the reporting procedures. Now we are saying on receipt of information from a person who has personal knowledge, they can actually issue an order,
so
a protection order.
This neighbor just hears screams next door and
pardon?
Like I want to understand the practical nature of this scenario.
Yeah.
Mm-hmm.
A protection, yeah.
Mm-hmm. Yeah, what is the...
Yeah. It's part of the process, isn't it? But it's like an injunction.
Other law. Mm-hmm.
Yes. Yes. What do you mean the victim is not involved in A? In B, yeah, in B it can be any other intervener. Yeah, it can be a neighbor. It can be a social welfare officer. It's part of the process. That's why I remember I was saying that if you look at the access to justice provisions, when I first opened up this amplifies or it supports the provisions under access to justice and effective response. In the beginning, when we got to this part, it's part of the process.
But someone who does not have that information, Ms. Jala, who's reading this document, if
okay, let's put it that way, Namibia. Can you draft something for us and let's put it in there? The way you understand it so that we can effectively capture what you intend it to capture.
My intervention is the fact that perhaps then if you're saying that it's part of the reporting process, then this aspect should be provided for under that reporting process. To say that it's the next... You're not in your, you're shaking
I'm
your
listening
head.
to you. I'm listening to you.
Okay. what I'm saying is that, reading it here, it seems a bit disjointed from that process. Because if I'm reading this provision for the first time, despite any other law on receipt of information from a person, you can get a judicial institution to issue a protection order. But in relation to what is the question?
No,
that I'm
that's what
asking.
he's saying.
Mhm.
That is what the input of that section. What you're saying, that's the input of that section. To say you can, as a victim, can apply for a protection order, or I, as your neighbor, I can apply for a protection order without your knowledge, because it even goes on to 2, and it says this can be done even if the victim is not instituting legal proceedings, which are that reported the top, that complaint and what. Even if those complaints are not there, it's saying I can apply for a protection order on your behalf.
Yeah, it's like how you do for injunction. An injunction is part of a process. You can't issue an injunction, or the judge can't issue an injunction unless there's already a case reported or a case started in court. You know that as lawyers, you know the procedure. So it's part of the procedure. In fact, what I want to add is the word temporary.
But
temporary
2A
protection
is going
orders. So
against
it's
what you're
part of, pardon?
2A is going against what you're saying.
When to a judicial issue a protection order without any requirement that the
It's
victim
not an
should
injunction.
other legal proceedings such as criminal, civil. Oh, yeah. This one, we've made it much easier. We've made it much easier than the injunction.
Yeah.
Yeah.
It won't be an
For obvious
injunction.
reasons. For
I
obvious
don't see
reasons.
the
But
reason, though.
I think
I
this.
don't agree with this one.
You don't agree with this one. But you want someone to be killed. Huh? Because this is a protection order. Huh?
If I can't go and report on my own, right? And then this protection order is given, and I'm not even willing to leave that house. Is it an effective strategy?
You see the problem here. I think we are looking at it very narrow. That's where I'm seeing. Because we all know what GB is and how it can cause either shame or fear in a victim. So you find a lot of victims will not report, or they'll be too they'll be shy to go and report it. So even a neighbor who knows that there's GBV under that, in that house, must be free to go and report it to help the victim. And I think that's why GBV will never be stemmed. Or people end up dying.
So implementation wise, I'm this neighbor, and then I go and I get this protection order. Then what do? I give this victim in their home, or I give their husband in that home. Okay, maybe the domestic setup is more complicated. Even at the workplace, how would it work on the ground? I think for myself, and I also think Namibia, that's what would like to understand how it works. Because it's very clear how it works if I as the victim apply for it. But if someone else applies for it, I'm failing to figure out how does it work? How do you implement it?
Normally what I've seen from other countries is when an intervener gets a protection order, right? They normally involve the police. Because it's a criminal offense it's like any citizen, you got a right of arrest. How does that work? How does that work? Because in true sense, since GBV is an offense, as a citizen, I've got the right to arrest for where I see any criminal offense being committed. That right is there. It has always existed. So in practice, what I've seen from other countries on these temporary protection orders is that you report the matter to the police, or when you do get a protection order, you use the police to serve the protection order on the perpetrator. It's just a mechanism to help prevent further GBV occurring, which may be of a serious nature, or help the victim themselves who may be in fear of reporting or too ashamed to report. That's what it enables it. If you leave it out, that remedy won't be there. And you just perpetuate, because there'll be no reporting. There's been a very low reporting rate for GBV. So unless you want to recraft it in a certain way that you believe it will work, but please, let's not leave it out, but craft it yourself now. Draft it and we'll change it so that it will work. But really not having an intervener to report on behalf or where they see a crime. In fact, even in law, if you don't report a crime, it's an offense in itself, at least in our country. Pardon? It's just a temporary protection order until proceedings begin.
Sorry. I was saying, so the effect
Can
of
you
this.
all participate in this? It's important. Let us see. So at the end of the day, we give either Namibia or Zimbabwe to draft what they feel will work, but let's debate it. Okay.
For me, it's not that I'm against this protection order. Let's first get that on the table. It's not that I'm fighting the protection order. I'm trying to understand how it will work. That's why I asked on the ground, and I'm the neighbor, and I get this protection order. What do I do with it?
Mhm.
And then you said for the countries that you have seen that have this kind of provision, they go with the police.
Yes.
So I'm saying, so if they go with the police and you're referring to this power of citizenry arrest, are you saying this protection order in a way functions as a reason for the police to officially go and arrest this person, or what?
Yeah.
Because we also have that reporting and complaining thing at the top, which can also still do the same thing and just lead to a person's arrest. Because I was wondering, we are looking at a domestic situation and I'm living with my husband in the same house. Is it a situation whereby the police will come with this protection order and then immediately evict this man from this house in order to make the protection order effective and await whatever other legal processes that will take place after? Because the subsection 2 actually says that this can be done regardless of whether there are any civil or criminal proceedings. This is a standalone thing that's just there.
Yeah, and I think I share those sentiments, and my initial intervention was also to try and understand
Okay,
or make
please,
sense.
can we have you draft it, or you'll draft it after, I think, let's hear from Seychelles, Mauritius,
I wasn't done.
Mozambique, and Situani before you conclude, or you still want to develop your argument? Please go ahead. Please go ahead if you want to develop your. Please, we are drafters here. We take hard criticism. So please continue, because we had your point, and
This is
it
a
was being
sensitive
developed
area.
by Zimbabwe. So I want you to give chance to the others, and then you can come in to help us how best we can redraft it so that it's workable. But I
point
want
was
to
not
give
to-
chance to the others also to state their stance on it.
Yeah, but the
And
point
then
was not
I'll
to
call you, because
redraft.
you are the initial intervener in this matter. So can we give chance before you come in to the others? Seychelles, can we hear what you've got to say?
Okay, thank you. Well, the way I read this section is that once the person who has knowledge of GBV, let's say he makes the application, and then the protection order is issued, will there be investigation? Will there be any formalities before that, or straight away just a protection order is issued? I would believe that there will be some investigation and leading up to the order. If that's the case, then I don't see any problem.
Yeah, but read 4.
Mhm.
Read 4.
But if that's not the case, then it's a bit arbitrary.
Okay. Okay,
you.
good. Seychelles, is that your comment? Yeah, can we go to Eswatini? While we are getting the other comments, can we read the entire provision right up to subclause 4? So you'll see the conditions attaching there too. Eswatini, please, can we hear what you've got to say on the temporary protection orders? Because there was a word temporary missing there, because these are actually temporary protection orders. They are not final protection orders. So please, Eswatini, can we?
I have no problem with the orders in our legislation, in our sexual offences and domestic violence legislation, the act and
Maybe can you're saying something important, but I can't.
in our act and in our regulations we have those. So I don't see any problem with them being instituted without the knowledge of the victim, because it is in the spirit of the model law and of course our GBV legislation.
Even I think we have it as well in our GBV legislation, and it works pretty well. Yeah, Mauritius, can we have your viewpoint, please, before we get back to Namibia?
I think if we add the words temporary, then it will make more sense.
Yeah.
So that in
It was
fact,
just an error, yeah.
yes. So that in fact, any person who has personal knowledge of any information will have to go to a judicial institution. That judicial institution on inquiry will then issue a protection order, which will then be enforced by the police. So that the police will then go and serve that protection order on that temporary protection order on the perpetrator of the GVB. But then probably subsection 2, clause 59(2), adds to the confusion, because when it says that without any requirement that the victim institute other legal proceedings, if it's a temporary protection order, probably there has to be some other legal proceedings that follow.
But did you read C?
Yes.
Which may be introduced as a material fact in any subsequent legal proceedings.
Yes.
Yeah.
But,
so it's assuming that there will be.
Well, it says without any requirement.
Because it's temporary.
Yes.
It's just temporary for the protection of the victim. Because if you go to 4,
yes, I've read.
You've read where it says to prevent
there's a
further violence,
yes,
to restrain the perpetrator from causing further violence to the victim, dependents, or we have to say his or her dependents, other relatives and consent persons.
For us,
that's the essence.
For protection from domestic violence Act, we have a immediate care and control. It would be a bit like this, so that you prevent further harm. You just go and do this. And then subsequently, there are other proceedings.
Yeah, definitely.
Yeah, thank you.
Eswatini had their say. Can we hear from Mozambique? Mozambique, can you repeat? Because the
Yes.
interpreters can't hear.
Yes. You
Okay, can you switch on your mic?
The mic is on.
Yeah, speak to the
Já,
mic
já,
so that
já,
we can hear,
já está
yeah.
ligado. E eu concordo que se pretende aqui a proteção, são ordens de proteção da vítima, então há medidas que têm que ser implementadas com vista a salvaguardar que males maiores ocorram. Então,
I think we can't hear.
Excuse me. Hello.
Interpreters,
Sorry.
there's duplication.
Wilfred,
Yes, ma'am.
Wilfred, our host, we have two interpreters
On the Portuguese
speaking at the same time.
Okay.
One of, okay, could we just have one of you speaking, please?
Just 1 second. Okay, I think now we are going to have only one for
Thank
English
you.
and one
eu estava
for French.
eu
Thank
concordo
you.
com a observação feita, que a medida pode ser acrescentando temporário, porque o que se pretende aqui é salvaguardar as vítimas da BGB. Nesse sentido, não se pode esperar que a queixa seja da vítima. Qualquer pessoa que se aperceba que há alguma violação pode intentar medidas com vista à salvaguarda desses direitos, para depois serem desencadeados os outros processos.
Thank you so much. Lesotho, I think you haven't pronounced yourself on this. Lesotho.
For me, the only input I would make to section 59 is to actually change the way subsection 1 has been
It's not
drafted.
happening.
But just a small thing, I'll
Check
just...
French is still on?
What? What now?
We didn't get you. We didn't quite get you.
What are you saying?
My laptop is crashing.
No?
Okay, I was saying what I would do to subsection 159.1. Okay, what I would do to subsection 1 is simply to take the last part of it, that is a judicial institution, and put it first. So this is how it will read. I'll simply say a judicial institution shall, comma, despite any other law, comma, issue a protection order and then continue. I would not start with a despite any other law. So I would rather take the judicial institution sentence to go above. Yes, but as far as yes.
Sorry, thank you, Lesotho. At least that will refine the drafting, but doesn't change the meaning. You're just bringing the subject earlier on. But don't you think, Lesotho, after doing that nice drafting, you still need despite any other law? Because in most cases under our common law jurisdictions, they before you can get any order or injunction, there must be already civil or criminal proceedings in court. And now what we are trying to do for the temporary is to say that despite there being no other proceedings started, criminal or civil started, you can still get a temporary protection order to safeguard life. And then the judge puts conditions on that temporary order.
If you heard me well, I actually included the despite any other law in my draft. I included it. So I said, this is how it's going to read. A judicial institution shall, comma, despite any other law, comma, issue a protection order, and then continue from A and B. So the comma will be in between that judicial office institution shall. Then you include that despite any other law.
Okay, great,
Yes.
great.
Yes.
So that is well done. In fact, that's what we need. So you see, he's just refined the drafting, but hasn't changed the content or what we are trying to communicate in the legislative proposition. So having heard everyone on the ground, can we have now Namibia address the issue? Because we've got Namibia, we have a small redrafting that Lesotho has kindly done for us. In fact, he stated, maybe you can repeat it yourself. Repeat it.
Okay, with sub 1, 59.1, I said I would read it differently and start with a judicial institution shall, comma, despite any other law, comma, issue a protection order. Then I continue with A and then B.
Thank you very much. So now can we come, everyone has pronounced, while you had stepped out, everyone seems to say we should keep it in the way it's subject to the redraft from Lesotho. So can we now, please, I haven't refined this. I was just I'm making sure that I remember that I have to bring this up. Okay. So can we, he hasn't changed the meaning, by the way. He has left the meaning, but he just brought the subject up closer to the action. Okay, the subject predicate. That's all he's touched on, the subject predicate relationship, which is very good. So can we hear from Namibia now? And you can amplify what you wanted to say earlier and move us forward.
I think my point was not to redraft it or to question its inclusion in the model law. My point, similar to Zimbabwe, was to understand the application of the provision and to understand how a protection order will be issued in the context of that subclause or paragraph 2 subclause B. That was my initial question. It was never to redraft it or to exclude it from the model law.
Oh, okay.
Oh, sorry,
Thank you.
sorry. For purposes of the others, I was asking Zimbabwe now to come in if she wants to further the argumentation or if it's clear now as to why we need a temporary protection order for cases of GBV. That is merely to protect any further injury or further GBV taking place. So have we made it clear? Everyone has spoken on the matter and they gave reasons why we need it. So please, you can step in.
Okay. Thank you. My proposal would be under 1B, we add with the consent of the victim. That's my proposal.
Okay,
Yeah.
let's go for T, and then when we come back, we debate the issue of the consent of the victim being put in. And we proceed for T. 15 minutes.
I'll come back at 16 hours.
Welcome back. I think we are a little late, but we can still catch up. We were looking at temporary protection orders. And if you can look at the screen there, the shared screen, I've now put it in the model law as suggested by Lesotho. Thank you, Lesotho. We started with the subject, a judicial institution shall, despite any other law, issue a temporary protection order. Then we continue. So we've got that. And then on the floor of the committee, Zimbabwe said in her remarks that if we put in consent of the victim, then it will be acceptable to Zimbabwe. So that's another debate point that I have to put on the floor because it's very substantial, that the intervener must have the consent of the victim before they apply for a temporary protection order. Can we have your views on that, please? Yes, Iswatini.
The issue of consent works well with an adult, but an adult, okay, but if it's not an adult and it's a minor and a person who cannot make a decision, like a person who is an imbecile or a person who I don't know how, or a person who is mentally challenged, I think in that case, then consent wouldn't apply. So my suggestion would be, with or without the consent, and depending on the circumstances, I don't know how we can qualify that.
Thank you. So Eswatini is saying maybe that can work for mentally disabled persons, and I mean that can't work for mentally disabled persons and children, but may work for the elder if the circumstances are clear. Because as we said, the whole reason for a temporary protection order and an intervener is that there are circumstances when even an adult will not report. For example, where she's living in fear, or what was that one? Fear or shame. She's just ashamed to report, or even her circumstances are such that she can't access a judicial institution or indeed the police. Maybe she's been restrained unlawfully and so forth. So there are circumstances when an adult also cannot effectively give her consent in such a situation. So if she's able to give consent, then she's able to actually go and seek a temporary protection order. So can we think this is following what Eswatini has actually indicated? Can we have Mauritius, and then Mozambique, Lesotho, and then Seychelles, and then Namibia on this issue?
Yes, I think there's no need for consent in this temporary protection order, because if she should there have been a need for consent, then probably that person, the victim herself or himself, would have gone to report the case. This is a case dealing with an extreme case where the victim cannot give a consent, but to probably deal with whatever problem that might arise, probably if there is a temporary protection order and the person is not agreeable, the victim is not agreeable to having it, they can say it once the temporary protection order is served upon them.
Thank you, Mauritius. Can we have Mozambique?
Eu acho que a ordem de proteção não pode depender da vítima, porque o que se pretende aqui é proteger. Há casos em que são menores, como a colega de Swatini esteve a dizer, são dependentes, são menores, são dementes. Às vezes é a própria vítima que não tem coragem de ir denunciar, mas que há necessidade, vemos que está em risco, até em risco de vida. Então, se nós conseguimos ver e nos aperceber que a pessoa está em risco, podemos desencadear medidas que possam impedir que tais atos possam ocorrer. Obrigada.
Thank you. Can we have Lesotho, please?
I think I also would go for like the motion not to really seek a consent in this regard, because sometimes the victims might not be in a state where they are able to really say they're giving consent or not, but it might be upon the state maybe to decide that this might be very in the interest of the victim itself to issue such a temporary protection order. So I would support that it be issued whenever necessary, without necessarily having to get the consent in that regard. Thank you.
Thank you, Lesotho. Namibia?
I think I'm inclined to agree with the notion that consent is not always possible in all scenarios, and for that reason, I think we can keep the provision as it stands.
Thank you, Namibia. Can we have Seychelles on the floor?
Thank you. I also have no issue with this provision. I mean, you don't need consent. This provision exists in many existing laws of many countries, so there's nothing new. So I'm happy with it.
Thank you very much, Seychelles. Zimbabwe, can we have your way forward, please? It was you were the intervener in this, yes?
Yes, I think the way
Oh, sorry,
forward
sorry.
would be the decision of the majority.
Thank you very much, Zimbabwe. Can we have Zambia? Sorry about that, Zambia.
It's okay, Chair. Thank you. I'm inclined to go with the position that's been presented by the team. Suffice to say that in our law, we have a three-pronged approach where you will have a friend of the court more or less dealing with a minor, and then you also have consent for a victim that cannot make an application on their own. And then you also have the third scenario where you seek leave of the court to do it without consent of the court. But that was just an example of what we have as a country. But my concern was with respect to the manner in which the judicial institution will receive this information. I note under A, we have said it's on application of the victim, but on B, it's just on receipt of information. Would this not be on application by a person who has information or knowledge of an act of gender-based violence having been committed? I'm just thinking of the manner in which this information is received and subsequently how the protection order will be granted. Thank you.
Thank you, Zambia. I think that's a good insertion to also put it on application from a person who has information. May I put it on the floor? Any comments on that? Zambia is saying that we should also follow the same process on an application, which we'll put it on top if we have to. Any objections to Zambia's insertion? Can I see any objection? I see none, so we shall add on application, which will now go in the chapeau. Rapporteur? Yeah. And then it will be on application of a victim or on application of a person. Oh. Then we'll draft on. Then we'll redraft it. Sorry. Okay, we'll correct that. Thank you very much, Zambia, for that insertion. Can we now proceed to 60? Financial empowerment programs for women and children. Any comments there? None, I see none. Let's go to 61. Mozambique, thank you, Mozambique. Please proceed.
Eu estou a intervir porque que era para conformar o número 2, a linha B, com a proposta que se fez no ponto 26, a linha G, que era para alargar o campo de dependentes. Aqui vem oferecendo bolsas de estudo e subsídios aos filhos da vítima. Então, se nós vamos colocar outros dependentes, há uma proposta de se alargar os dependentes no ponto 26 que tínhamos visto.
Committee members.
26, orientação de política geral, tendo em vista os direitos humanos. Então, na linha G havia uma proposta, eu tinha sugerido, e ficou em aberto, que se alargasse a abrangência, que vinha disponibilizar apoio adequado aos filhos das vítimas. Então, nós tínhamos proposto que acrescêssemos as vítimas também. Então, se nós alargamos aqui no ponto 26, ali número 1G, há uma necessidade de conformar com este ponto 62B, que para além de oferecer as bolsas de estudos e subsídios aos filhos das vítimas, essas sejam alargadas também àqueles dependentes que a gente vai incluir aqui neste ponto que se refere à orientação de política tendo em vista os direitos humanos.
Thank you very much, Mozambique. Committee members, please take up that point.
I have a question.
I'm just trying to get you to 26, just to pin 26. I think it was G. This is what we did to 26, providing adequate support to children under the care of a victim. And she's stating that if we can do the same with the provision that's under discussion. Lesotho, you saying you had a question? Please proceed.
Yes, I think my question is related to maybe trying to abate the possibility of an exploitation of the provisions like this one. Where they're trying to provide financial assistance. I just want to know, for these children to be maybe considered to qualify for this kind of grants, should it be because their parents who have suffered a GBV violation. Maybe that GBV violation led to a loss of income or livelihood, or just because somebody has just suffered that, automatically their children has to be given this kind of incentives or grants. So much that sometimes you find that people are still working and they're still being able to take care of our children, but they can still become victims. So, I mean, do they automatically say, no, we will approach the government and now our children now qualifies because the law says once I'm a victim, my children should be given this kind, because that's usually what people are likely to going to end up exploiting. So I just want clarity on that. Thank you.
Please, committee members, take up on both points put on the floor. Let's hear your views. Mauritius, and then Namibia, Zimbabwe, Eswatini, and Seychelles.
I think clause 26 is broad in nature, saying that the government should do these things, whereas 61 says the minister responsible for education. They do merge because it's about the same thing, but then probably if we can have 26 nearer to 61, move it here so that all the social, educational, and other social and other measures can be grouped together. That's one suggestion.
Okay.
But I think there's no contradiction. Government or the Minister of Education would have to provide support.
Okay. Can you address the second issue as well from Lesotho?
I have said it more than once. I think all orders are might be abused by victims, but it is for the court to decide whether there has been any abuse or not. So the court is there as a barrier to see that there is no abuse of the system. And if there's an abuse, then later on further evidence can come in, and that order might be discharged.
Okay. Before Mozambique and Lesotho come in, let's have Namibia.
I don't have any opinion on the
matter. Can we have Zimbabwe?
I also don't have any suggestions on the issue, this specific issue under discussion. I was fine with the way it was.
Okay. Eswatini.
I also don't have a problem, also because this could be addressed in subsidiary legislation and guidelines and other processes that would be put in place administratively.
Thank you, Eswatini. Can we have Seychelles?
Thank you. Yes, I endorse the position of Mauritius. But in general, I don't see any issues with the way it is now, the wordings.
And what about the issue raised by Lesotho on possible abuse of such entitlements?
Well, it will be up to the procedures and guidelines, how you apply for it, you know. There has to be checks, there has to be system in place to prevent all this abuse.
And this one is not mandatory, Lesotho. If you've seen, it's just incentives. They may establish or they may not. So can we hear now from Mozambique on the way forward and Lesotho? You've heard the comments from your colleagues. What are you still, do you still want to change this provision? Or would you maintain it?
Podemos manter como está.
I mean, we are not, we are, I don't think anyone is objecting to couch it in the same way that we couch 26, if I've understood the flow. There's no objection to doing that, but it's more of the abuse of the system that may result, especially now that we are opening it up. Mozambique? Are you fine by that? Okay, thank you. Lesotho?
Okay, for as much as it is not compulsory or mandatory, I feel like where and when countries decide to adopt them, at least this provision should be qualified to say it should be in instances where there is proof that such violations actually affected the livelihood of the children, so much then that the incentive will be to try and put the children back to the normal root cause or the normal life that they were to live had their parents not suffered such. It shouldn't just be just because there is a valuation, then they qualify, but we shouldn't qualify that the incentive should only be introduced where. That is in the case where countries have decided to adopt this. Thank you.
You say affected by the way, affected their status, basically, isn't it?
Yes, yes.
The
The
way they used
violation
to
has
live.
actually now impacted on their lives so much that it's not, they are now worse off. So to try and put them back to their normalcy or the normal way they were living before the violation, then the incentives should kick in. There shouldn't be like a straight qualification once there is just a violation.
Okay. I'll just
Chair.
put this as a reminder. Yes, Mwenya?
Yes, Chair. I was just thinking, I know 2 is merely persuasive, as was already indicated. And secondly, it's just providing examples that you can adopt as a country. But of course, even as we adopt the model law, of course, we'll have broad provisions, and then for the specifics relating to what the processes and procedures are, those would go in our subsidiary legislation as a national country. So I'm thinking we wouldn't want to put too much here. All we're saying is that they can get incentives, and these may include the 2 that have been put there, but there could even be 10 that a country is able to provide. So of course, in giving that incentive, you will need to provide a procedure which will then incorporate the extent to which the victim has been affected by the Gender-Based Violence Act. So I'm thinking this would be best left to subsidiary legislation. Thank you.
Thank you very much. I think we are generally agreed on these issues. So we will just redraft it to take into account Mozambique and some issues raised by Lesotho. Okay, so we can proceed. 61, educational and social measures to empower women and children. I see no hands. Can we move to 62? Surveillance to protect victims. I see none. Can we move to 63? General measures, interventions, protections, and entitlements relating to families. I see no hand. 64, requirements relating to safety homes or shelters. I see none. 65, strengthening community networks. Thank you, Iswatini.
Yes, on the issue of the shelters.
Yes.
Can we have a provision for guidelines, because these are not, of course, they are not exhaustive, but the government has to have guidelines in place to ensure that even though someone sets up a shelter, that person has to comply with the requirements of government for purposes of ensuring that the shelters that are private are not so different from what government prescribes.
Okay. I'm sure you've all heard Iswatini's comment. It's that we should provide in 64 for the issuance of guidelines. So the guidelines will apply for both government shelters and civil society shelters. Am I right? Yeah, on the establishment or the construction of infrastructure of shelters. Any comments on that issue? Any comments? Are we agreeable with Eswatini's insertions? I can see, Guy, thank you. I'll just put a note here and draft it in later. Okay, can we proceed to 65, strengthening community networks? I see no hand. 66, access.
Can I ask something and hopefully take you back? Can I take you back to 64?
For strengthening networks?
Yes. No, requirements relating to safety homes and shelters.
Okay.
From where I'm reading it, does it is it only limited to the victims, but not the children of the victims? The provision of their safety homes or shelters. It looks like it only caters for the victims themselves.
I think when you read the essence of the law, I think it's also for their children. So we can add. What do the rest of the committee feel when you look at from where we are coming from? Because we were also adding children where it came to the privileges and support services. So Lesotho is proposing that we add children. Yes, Eswatini?
I'm not sure, but maybe I think this is covered in the definition of victims. If we can look at the definition of victim, I think this is covered there.
Okay, let's look at the definition of victim. Victim means a person who has been subject to gender-based violence or discrimination and who individually or collectively has suffered harm, including physical, mental harm, emotional suffering, blah, 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 blah. Employment laws enforce, including a survivor, and the word survivor shall. Let's go to the avoidance of doubt clause. A person who has been subject to gender-based violence or discrimination shall be a victim regardless of whether a perpetrator is identified. No, it's not included. I think that's why where it's necessary, we've added children.
If I may.
Yes, Namibia.
The same provision under subclause B provides that shall be a victim where appropriate includes the immediate family or dependents of the victim and persons who have
in
suffered.
the definition?
Yes, that's same, the abundance of caution definition for
Okay.
B.
Maybe I read it too fast. Yeah. Carry on.
Includes the immediate family, dependents of the victim and persons who have suffered harm in intervening or assisting the victim. So the immediate family and dependents of the victim would be included in that definition of victim.
Sorry, I'm sorry, Swatini, I didn't read further. Yeah, immediately family or dependents. Even Mozambique, have you seen? Your major problem has actually been resolved in the definition. Where appropriate includes the immediate family or dependents of the victim and persons who have suffered harm in intervening or assisting the victim or in trying to prevent victimization. So most of your problems have actually been taken on board in the abundance of caution clause. Let me just put on my, I'm so hopeless at languages, okay? Yes.
¿Cuál es la palabra que define?
It's already taken care of in the definition of victim and in subclause 2, which we deal with abundance of caution clauses. So if you read the one saying for purposes of the definition of victim, and you go right down to the end, B, you'll actually find most of your problems that you were raising is actually covered.
Okay.
Are we okay? Okay, good. So let us proceed. 65, strengthening community networks. I think we have done that. Let us go to 66, access to general services. Let us move to 67, funding of programs, measures, interventions, incentives, and services. I see no hands. Let us go to part 7, access to data and information, capacity building, public awareness, monitoring and evaluation. 68, evidence-based information and data. I see no comments. 69, access to information and data on gender-based violence and human rights. Yes, Zimbabwe.
I would just like to make a general comment, not necessarily about the wording in the provision, but
Okay.
for those countries that have protection of privacy or to privacy of information, is there any need to link to that and try and ensure that regardless of that privacy, this access should still be there?
Yeah. I think that's very important. Where you've got privacy legislation or access to information legislation, you are better off cross-referencing to those laws to ensure that there's consistency. So that's a point for all of us to take on board, that please, if you've already got this data, information or privacy protection legislation, please let us do effective cross-referencing. These provisions here are put for those countries who don't have such legislation. Or maybe if your existing legislation is not up to the standards of the model law, maybe you can also amend consequentially those legislation, then cross-reference. Yeah, okay, I think that's very important. Thank you, Zimbabwe, for that. 70, public awareness. '71, information and media. I see no hand. 72, training of public officials.
I have a question.
Yes, Namibia, please go ahead.
In the first sentence, child prohibition officers. What are child prohibition officers?
Training of child prohibition. Prohibition.
There's such a post called a child prohibition officer.
If maybe we go back and just for purposes of this role, so you will put your appropriate titles, those that are appropriate in your jurisdictions. So for this law, we've called them child prohibition officers. I think that's what we defined.
I think it's
let's check.
probation.
You have checked the definitions? Because I think all along that's what we've been calling them. Child. Maybe it's probation, I don't know. And that's what we've been calling them throughout. Huh?
I think
so it's not even defined.
Yeah.
They're not even defined.
I think it's a typo in spelling. Technical term at least is
Anyway,
probation.
let's put probation for, and then I'll check if it's been used like that throughout, then we may change them.
Okay.
48. And so let me just put a note that C48 as well. C38, 48.
4A.
Thank you for that. Okay. Any other comments there? 73. Regular monitoring, evaluation, and reporting. Oh, on this one, I wanted to, I don't know, I think it's Zimbabwe. You raised the issue, I think in your presentation on the committee. Remember the committee? Yeah. So what the SG was talking about when she raised the issue of committee in her address to us, she meant the SADC Parliamentary Forum. So the SADC Parliamentary Forum has a committee, a monitoring committee. Yeah, so please, can you just explain it further? Yeah, so that, yeah.
Yeah, it's a committee made up of chairpersons of committees of the forum, and it's called the Regional Parliamentary Model Laws Oversight Committee. And what they do is...
Sorry, mine is not this one.
Sorry.
Pardon?
Mine is not this one. The one I was speaking.
Yeah.
I'm keeping this mask. Sorry about that.
Yeah.
I'm saying the committee that I was talking about, it's not this one. It's not under the one under 73.
Okay.
Mine is the one under 75, I think.
75.
Yeah, the proposed internal one. Not 7. It's not even 75, sorry. It's not even. Okay, let me just go to my presentation. It is that committee, the Internal National Committee, that coordinates the work of the country in terms of responding to gender-based violence, the one that makes proposals to the minister and so forth.
Yeah, so that's the one which I think she's explaining.
77, that's
77.
the one.
Let's look at
That's
this
the
one.
one I was referring
Because
to.
the 77. Office or Constitution of Committee. Okay.
Yes.
So this is the interministerial.
Yes. Exactly.
So that's the one we are talking about.
Yes.
Okay, fine. Because we were a bit confused. We weren't sure which committee you're talking about.
Okay.
Yeah. So there's basically the one which is involved with coordinating and reporting on what's going on in various SADC members is the regional.
Okay.
Regional one.
Okay.
So maybe this is just interministerial.
Yes.
Yeah.
Yes.
So it's restricted within a national state.
Yes.
Yeah. A member state, sorry. Okay. Where were we now? Okay, so 73. Any comments on that? Part 8, enforcement, compliance, and regulatory. 74, general state action. I see none. 75, notification and reporting mechanisms. I see none. 76, anti-gender-based violence fund or alternative financial resources. I see none. 77, anti-gender-based violence monitoring officers or constitution of committee, their functions and duties. Would you like to raise your issue now here, Zimbabwe?
Fine. I think the issue that I had raised at the time of my presentation was that I wanted to understand from your perspective, considering that you have gone into much deeper research than I think we would even be able to try and understand the best approach that states can take. Because when I read 77.1, it gave us the idea that possibly it's just an interministerial committee that's appointed and given tasks to ensure coordination of every stakeholder that's taking part in the process of fighting gender-based violence, whether from prosecutors to the people with the shelters, referral from police, etc. And then I was saying, but when I went to the functions, it seemed more like it's a committee that is set up, not necessarily restricted to players that would be monitoring and coordinating efforts, but with actually an independent mandate to prevent gender-based violence, collect evidence, advise, create awareness, sensitize communities. So I just wanted to understand which would be the better, or maybe we can try and consolidate the same add-on functions, I suppose, to what we have, or maybe the way it is, it's enough to cover everything.
Mm-hmm. So our research actually is stating what you are actually saying.
Okay.
That's what we think. We thought that either if countries feel that it will be more effective using one officer, they are free to do, or create an interministerial committee to enable them have a whole government approach, you know, a cohesive approach in how you exactly put it, dealing with prevention measures, all these things that we're talking about, and ensure that the provisions of the law are effectively being applied. So that's the interministerial one. It actually gives you more cohesion, but it's really up to you as member states to select the most effective. I know, for example, in Zambia, they prefer interministerial committees to actually bring about an all-government approach in dealing with the subject area. So it very much depends on your own countries, how you see it spanning out, which is the most effective procedure in ensuring everybody's doing what they're supposed to be doing. Remember what we were saying, the close supervision issues and things like that, monitoring, evaluating if the provisions are doing well or not. If not, maybe suggesting appropriate changes in administrative, legislative, or financial provisions to make it more effective. So really, it depends on yourselves.
Okay, so does this committee oversee the use of the fund, or the fund is housed somewhere else?
I think
Considering
the
work that
fund
they're
is
doing?
housed by the ministry itself. So the ministry will take care of this. These just relate basically to the operational aspects of monitoring and evaluation, the GBV management process.
Okay,
Yeah.
okay. Thank you.
Thank you, Zimbabwe, for that. Let's move to 78 compliance notices. I see none. Can we proceed to 79, access to premises, documents and information? I can see there's another prohibition here. Let me just mark it. Oh, I know where it's coming from. It's coming from the child marriage model law, where we had actually prohibition officers. But for this one, I think it's best to change it to probation. Yeah.
Actually, perhaps on this one it applies, because the child marriage
Yes, it comes
prohibition.
from the child marriage.
So it's prohibiting the officers.
Child marriage, yes.
So this one we don't change it.
We don't change this one.
Yeah. Oh,
Okay.
I see.
And I
see
think-
what you mean.
Yes.
I see.
Yeah.
Makes sense.
Then in the other context, it would then also be the missing word would be marriage. Not that.
There, yeah, the other one, yeah. Yeah, yeah, we'll take note of that, Mr. Jerry. Please, let's take note of that. Any further comments here? I see none. Let's go to 80 general offenses.
I think my question, it's more of a question. We said here, a person who refuses to answer any questions, fails to produce any document. Okay, we are saying the victim can give false information.
No, not the victim.
Yeah,
We
because it
remember we
says
excluded the
except-
victim.
Yes, it
because
says
we've got
except-
all those other protections which we have put in. Remember, under access to justice. So we're saying any other person except for a victim who is a woman or child.
Okay.
Yeah.
So are we indirectly saying they can falsify information?
Yes.
Because as a victim, it's not necessarily, I guess it also goes back to when does somebody become a victim? Is it when they
Exactly.
report, when there's actual conviction of this perpetrator or what? Because how would we then guard against the malicious reporting? Those are, that's what I'm thinking. Because I see how it's very important, because it's like asking a trafficked person, it's like how you protect a trafficked person from conviction of immigration laws and all those things. Because you were a victim, they took your passport, they made you, they smuggled you, all those things, you need to be protected.
Yes.
But then I'm thinking, in this scenario, it's like we're between a rock and a hard place somehow. I don't know how the others feel about that. I see the value of it, but I'm also seeing the possibility of
Yeah, even it gave me quite a lot of problems. As I said, most of these are sort of the gold standard by the UN. But it gave me a lot of problem that if we are accepting, we are saying accept a victim who is a woman or child. Why are we excluding the victim who is a man? Do you know what I mean? Because even them, they are given their protection under the access to justice provisions. We did not exclude them from that. So I'm still like a bit not happy with this exclusion, I may say, but I understand that these may also fly in the face of the access to justice provisions, which actually give them protection that, you like the cautionary rule that always requests collaboration. And then if you've given false or misleading, that can be used against you. But in the access to justice clause, those have changed, right? You say, so as you said, and it's at what point? You have already a victim because you were abused. And then when you report, you're reporting as a victim, but are you allowed again to distort your evidence before them? It's a lot of jurisprudence in relation to that, but I don't know what balancing acts we can use here. Because we do need these offenses, that there's some people who actually just give false information. You see what I mean? Yeah. So it's really up to you. How do you think we can best preserve the protections we have given, but at the same time ensure that any person who actually reports falsely or gives materially incorrect information, how do we deal with them? Because in most of our laws, those are already basic offenses. Yeah. So this gave me quite a lot of problems. I think so. So for the time being, I don't know how you feel for us to remove except a victim who is a woman or child.
I think to leave it reminds us of the situation.
The except for?
If you leave it, we'll remember to look more into this, because we still want to protect the victim, but we also want to protect against abusers of the system. So I'm sure everyone, when they see this, when they are now drafting, they'll remember to try and strike a balance to protect to sort of protect the previous protections that we've already given, and also be wary of the other dimension of the malicious.
Have we all taken on board what Zimbabwe has raised? And how do you feel about it?
Can I say something?
Please, Lesotho.
I think we should probably add an extra provision to expand on what has been said here, so much that we try and qualify it in a way, because I think if we just leave it hoping we'd remember, I mean, we run a risk, because sometimes by the time some of these laws are adopted in our respective countries, we might not even necessarily be in the office of OPC by then, or for any other reason, because like gender issues are cutting across so many other laws. Does not mean we're going to, all of us who are in here maybe be attending to all those laws. So what I'm thinking, because now it seems to have excluded the woman and the child, but maybe add another provision that actually now give sort of an obligation on that woman or child, says, but for this particular, or where there is a suspicion of this and that, then they can be maybe ask the questions, but not just always ask them questions, but we say, but or maybe on those exceptional circumstances, maybe where there's a suspicion or something, so that they also don't get to abuse the system and just start laying claims and knowing that nobody will ask them anything.
Okay.
Thank you.
What if we also add a person who willfully, that they're intending actually to commit a crime by providing false information? I mean, so that it ties up with our other criminal laws in relation to these sort of crimes. I don't know.
I think it will still be okay. We just have to beef it up a bit, instead of leaving it like it is.
Yeah. Okay, let's we will try and see what we can do about this in order not to really because we should accept that there's other criminal liabilities arising from certain actions of the individual. It doesn't matter whether it's GBV related or in relation to another crime associated with GBV. Those can't just be easily ignored just because we are trying to create special protections. So we'll try to think about it and see how we can beef it up, as Lesotho has said. Okay, thank you. Okay, let's move to 81 regulations, rules, and guidelines. Oh, by the way, your guidelines are here, Eswatini. Yeah, the guidelines are here.
Can I say something? I noted that we have them, but then specifically for the shelters.
Okay.
I thought those should be,
okay,
flagged better than these ones here.
Okay, we shall maintain them there and beefed up in this particular provision. That's fine. Schedule 1 is just a listing of the international agreements, the key international agreements on GBV rights. Those are the ones we listed here to ease member states' research. Schedule 2 is the source materials on GBV that were used for developing, and these are just the key source materials, developing the law, so it can also help you counter check under these source materials to ensure that we've captured the essence of the management of GBV in accordance with the international standards. Any other burning issues that any of the countries wishes to raise on the GBV before we close? Yes, Eswatini.
Yes, thank you. I'd like to add on what I've just said about the guidelines. The reason why I'm saying this is because it takes time to enact legislation, subordinate legislation. And if these guidelines are going to, for instance, come under a subordinate legislation, then there would be no guidelines for shelters before the enactment of that subordinate legislation. So the guidelines have to be there even without the subordinate legislation. Thank you.
Thank you very much. Okay. Is there another country wants to make a general comment? I don't see any. May I hand over? May I thank you first for all the assistance you've given me. Very valuable comments, changes, drafts, and I'm most appreciative. I can assure you, I'll take everything on board and much, much more. Just listening to your general argumentation on the model law it will help me now enhance the model further and really check it out, proofread it, so that it meets up to standards. I thank you most sincerely, each and every one of you, for your help in this respect. May I hand over to the Director of Summary?
Thank you, Mrs. Jala. And once again, colleagues, thank you very much for your participation, for your coming. And I think I'll leave it to the Secretary General to formally thank all of you. I hope she's online now.
Thank you, Ms. Musonda. Good afternoon, colleagues. Good afternoon, my hardworking partners in this region. I think I'd be happy if you can really mark the end of this day with a round of applause for all of you. I see the hands clapping and I'm quite happy. And I say this from the bottom of my heart because I've watched you tirelessly engage. You know, I went through various emotions at the beginning, in between, at the end, when the first question was asked, when the presentations were made, when the responses were made. But all of you warm my heart in terms of how you came together and collaborated on this important exercise. And I would have, you know, put all my support behind, you know, any other requests coming into the future, and now coming from the Director of Ceremonies in support of bringing you back again, should she say, we need the drafters one more time because they have to look at this. I've really been impressed by this, and I hope that if such a call comes your way, you'll be able to sincerely honor it in all, you know, within your given, you know, busy schedules that you have. Colleagues, let me just, you know, share with you, you know, some writing of an American businesswoman, Mary Kay Ash, who famously said, and I want to quote her verbatim, there are three types of people in this world: those who make things happen, those who watch things happen, and those who wonder what happened. As if not to be outdone, we also have Frederick L. Collins, who said, and I quote, there are two types of people: those who come into a room and say, well, here I am, and those who come in and say, ah, there you are. These are the emotions that I went through when I joined your meeting, when I listened to your engagement, and you can guess what type of people you are. We have come to the end of this intense consultation, and I say intense because you've sat there day in and day out. I'm sure you went to your rooms, went back to the model law and looked at certain parts of the model law and decided to say, tomorrow, this is what we're going to dwell on. When you decided to go clause by clause, this really made me happy because this demonstrates the thoroughness that which I attribute to drafters such as yourselves. And I would not have been surprised if you did it. I would have been surprised if you did it any different. So I sit here today, or I stand here today across the miles to really congratulate you for your chosen career, for the passion and commitment that you've demonstrated, for taking time out of your busy schedule, for traveling when it's risky to do so, and for ensuring that you really give us the privilege and honor as a SADC Parliamentary Forum to walk with our heads high after you have looked at this model law. And we shall be quoting at every given opportunity to those who care to listen that the SADC legal drafters looked at this model law, and therefore we are confident that everybody else should be able to appreciate this. So mine is just to thank you as participants for attending. This has been overdue. It has been very highly interactive. Where I said it has been very informative. Your engagements have really been enlightening. And I believe I speak for many at the Secretariat who have been logged in to watch you, and those who are seated there with you when I say that well done. We really much appreciated what you have done to go through this model, and we look forward to you even giving us any further, afterthoughts beyond this process. A big thank you to our legal drafter. I think she deserves a round of applause. Yes, she always puts her best foot forward. Even when she's tired, she always makes sure, and I can tell you, she will look at everything that you have said, and she'll make sure she incorporates it. If you allow her as well, avail your numbers so that she can follow up on some of the issues that you've raised, because sometimes, a bell rings in the middle of the night and you want to follow through that particular contribution that somebody has said. So with a deep sense of appreciation, thank you very much for facilitating this session and really for also taking your time out. You could have said, well, it's supposed to be COVID, I'm not traveling, but you've come through, and we consider you as a friend of the forum after you have set the tone for how model laws should be developed. You have set the tone for the marriage Bill of Rights, the Child Marriage Bill of Rights, now the gender-based violence. And we believe that drafters around the table should begin to write about such regional initiatives and extend the dialogue so that people in the same sector can be able to look at the principles that you're speaking to, the new drafting styles, how we should not be blocked by style and form, how we should be looking at research, and how this should be a revolution in areas that we feel strongly about, like gender-based violence. Whether we can form a group that can look at some of these new issues that are offshoots from such processes is a matter that I look forward to. Let me also thank our interpreters from where they sit for the logistical support. This is our first hybrid meeting that we've held. And as you have seen, we do not have interpreters sitting with you, but the work was done and without any complaints at all. Also allow me to thank my colleagues at the SADC Parliamentary Forum for the enormous support and cooperation in putting together this meeting. Even when we felt this meeting may not take place, they persevered day in and day out. They did the necessary research, and here we are. We have no regrets. Their willingness to do so is what we all look forward to in terms of cooperation. And I'd also like to thank your hotel for the support they've given you. I believe you really slept well where you are. You've enjoyed the food, I hope so. And all these things would not have been possible without a bird's eye view to detail, which our director of ceremonies and her team put together. And we are fortunate to have such a team at the forum. And I'm very motivated by this session today. You are dedicated colleagues. Although you come from various countries, you have shown that regional integration is possible. And this has been such, heartwarming for me to engage with, albeit virtually. And I'm convinced that this trust, this collaboration will make a huge difference in the lives of women and girls, men and boys, and it will contribute greatly to the eradication of gender-based violence as one of the many instruments or efforts that have been put in place. So let me not squander the opportunity you've given me to say thank you to you by talking forever. It just shows you how happy I am. When our daughters, grandchildren, and great-grandchildren look at this model law, they will be able to really appreciate that we really put our best foot forward. And thank you very much for giving me this opportunity. I wish you safe travel back to your countries and hope to see you again. Maybe when we adopt this model law, which will be in Lesotho, at the 50th Plenary Assembly session, you will all get an invitation and be able to listen in to the good work that you've put together. Our choice is very simple. We opted to be part of the solution to the problem. We can opt to be a solution to a problem or to be part of the problem. So we chose wisely And thank you very much for your active participation.
Thank you very much, SG. And with those final words of thanks, I think our meeting is closed. Thanks, everyone. You've been a very good team. No difficulties at all. Thanks so much.
Bye, everyone.
Bye.
Oh, I see Botswana. How are you, Miss Kelly?
She's finally here. Who's that? Botswana.
I thought I saw her.
Hey, we've been trying to get her. We have Madagascar and Zambia by Zoom.
Oh, thank you so much, Zambia and
Those two were led by
Madagascar.
Zoom. Yeah.
And they sat through.
And they've contributed very well.
Oh, no, thank you so much. We'll send letters of appreciation to your institutions.
indeed.
Thank you so much.
You're welcome.
Thank you. I hope everyone has their travel. Are we closing the meeting? Wilfred.
Yes, ma'am. Can I close now?
We can close. Thank you very much.
All right.
Okay. Bye.